Hello, 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 hello.
No, they will be muting you, right?
Hello. 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 Hello.
What do you want? I mean, you have only one case or how many cases? Every day you are here. What do you want? Yes, tell us. We have given a date, right, of your choice. You want a date. What is to be done in that case? Why do you want listing? I mean, a notice has not been issued as yet. All right. Tomorrow.
Last occasion, I approached this honorable court, madam. My posting is not posted. My matter is the already direction is there, madam, not yet posted, madam. Lordship will
What
direct
direction?
me to approach the.
What is the urgency, Mister? You must tell us. You
If
want
not played by
for
the-
what purpose you want the listing? Is it a fresh filing or a pending matter? Very often
Pending
we
matter,
find
madam.
pending matter.
Already I gave a
It is
request to the
pending
registrar, madam.
since. It is pending since when?
4 months back, madam.
No. When did you file? The petition is of the year 23.
2023, madam.
What do you want? Why do you want its listing?
Already pleadings over, madam. Except the government counter, all pleadings are over, madam.
No, then file an application for urgent hearing. It doesn't come up.
Already I gave a letter to the registrar, madam.
Letter not file an application seeking the early listing of the case. Then it will come up on that petition. Yes.
So already I have done that portion.
When have you filed?
This is there, madam.
Application, not letter.
Yes, madam.
Application to the court. Yes.
May I please, Lordship?
Please.
Matter pertains to medical admission. Lordship,
Medical admission. What?
Lordship, pleadings are completed. Lordship, I would directed.
No,
by-
same early hearing file, assigning urgency. This is not the way to get the listed file and not argue cases of 98, 99 and 2023. Say that 4 months ago I have filed and it should be heard today. It's not like
We
this.
have filed.
Next.
With medical admission matter, my lord.
Fresh matter.
My lord, 2023 matter, my lord. Now, my lord, she has to get admission, my lord, she, the petitioner. Your lordship, earlier directed in other petitions, my lord. But
No, mister. We are asking you whether you have filed it today.
yes, ma'am.
Today.
Yes.
Fresh admission,
Yes.
not listed. Tomorrow.
Lord.
Yes.
It will like kind permission, Millards, there is a number CO MC8, that is 8 of 23. This is not before Millards listed today. What has happened in this case, Millard, is that it was last
Want hearing.
Millards, I want
Final hearing.
I want hearing, that's it.
Final hearing, then you will have to, like the uniform rule, we don't fix it by mentioning.
Actually,
You
what
will
I-
have to file an application for urgent hearing. Unless you want hearing on some IA or something or admission, then we can.
IA, what had happened was this, it was listed before Millard Justice Naveen Rao's bench. I am an appellant in a Millard's arbitration appeal. And Millard's stay, I am pressing for a stay application. What has happened is this, Millard's, it was heard.
Answer is simple, right? That I want orders on stay application. That's
Yes.
simple, right?
Simple.
You were before him or which judge, we don't know. It's irrelevant according to us.
So it
Yeah.
has not been listed since 2nd of March. Millards were listed, Millard, 3rd week of October, subject to Millard's pleasure. Because Millard 31st, Millard's the execution petition is being pressed, Millard's 31st October is the date.
It will come up only on IA. Where is the mention memo?
We have got.
Which date? You are an outstation counsel.
Millards, I come from Delhi.
Oh, you have come only for mentioning.
No, Millards, I have other matter before Millard Justice Vijay said Reddy.
No, whatever, wherever it is, we are not concerned.
So Millards, I am for some other matter.
Third week,
Millards, so 17th October, Millards, or 18th October.
list for consideration of this thing, interim, this thing, prayer for IA on 17th October. Yes, next. Madam,
Millard,
all the
this PIL posting matter. Millard, this PIL posting matter, Millard, bill number 107 of 2019. Kindly post tomorrow and
Why?
Monday, Millard. Millard, last time this honorable court.
so why do you
directed
want
to-
again same query, mister? Every time we have to explain it to you. You have not been hearing that for what purpose you want listing.
Millard, last time this honorable court directed to file vacate stay and mention Millard. Vacate stay petition has been filed, Millard, kindly post.
You want vacation of stay. You want orders on that. What do you actually want? What is your request?
Posting, my lord.
Posting, okay, you have to explain the exigency in it. Or file an application for expedite hearing, that's it.
My lord, before in a day, this honorable court directed to stay further construction, my lord. The respondents, we are unofficial respondents, my lord. Unofficial respondents.
You want orders on
literally-
vacation petition, right? Is it correct? Vacate petition, you want orders on vacate petition.
Yes, my lord.
When have you filed it? So it's so difficult, Mister, to tell this. So difficult that I have filed an application for vacating stay. That has not been listed. It is so difficult, right?
Vacating stay has been filed, my lord.
You don't understand. We'll fix it on 27th September for orders on vacating stay.
For placement.
Will issue notice. Issue notice
please,
of
Your Lordship.
IAS. Issue, yes, madam.
I'm for the appellant, my lord. And this is an application filed against the
Issue
order.
notice of IA 1 of 23, 2 of 23, 3 of 23. Office is directed to secure the record of the commercial court. List after respondents are served. Yes.
Much obliged.
Yes, what is the direction you are what direction?
My lord, I am asking, my lord, for some bank guarantee from the other side.
Heard on the question of admission. Appeal is admitted for hearing. Issue notice on merit as well as IA 1 of 23 record. Office is directed to secure the record of the commercial court. Next.
My lord, I'm sorry, my lord. The first matter I am appearing for respondent. I filed caveat, my lord. They have not served any copies.
Lord, I have filed a IA with a delay of 136 days. IA 1 is for condoning the delay of 136 days.
Oh, yes, madam. What is?
I have stated at paragraph 6 of the IA, my lord,
Yes.
the delay of 136 in preparing an appeal.
But I am
No,
representing.
apart from delay, you have to tell us
Yes.
why we should issue notice on condonation of delay.
My lord, the order of the learned single judge was to be implemented within a period of 2 months from the date of receipt of the order, my lord.
You have implemented it.
No, your lordship.
Sir,
My lord,
we are talking about the legal issue, why it should be entertained. You are saying that
the legal issue
2
is.
months time.
The-
Legal issue is 2 months time.
No, your lordship.
It
The
should
legal
be
issue
4
is-
months.
The legal issue is like this, my lord. The petitioners are claiming land, my lord, to an extent of 32 acres.
No,
which they
madam,
have-
read para 11. 7th line. Respondent number 8,
Yes.
Mandal Revenue Officer is the counter affidavit.
Having regard to the paragraph number
11.
11, my lord.
Ah,
Having regard to the rival contentions and the material on record, the undisputed facts,
6th line. Respondent number 8.
the respondent number 8 in his counter affidavit has clearly admitted that the petitioners are assignees of certain land in survey number 427 of Parpelli village and are also shown as Patidas in the revenue records. But he denies that 32 acres of land allotted to the forest department is the land which was assigned to the petitioners herein. He submitted that the petitioners were never in possession of the subject land. In respect of the land which was allotted to the petitioners as recorded in the revenue records, it is submitted that the assignment register is not available due to burning down of the office twice by Naxalites. However, the non-availability of the assignment register is not due to any reason attributable to the petitioners herein and the petitioners.
Therefore,
My lord,
since
the-
you admit, madam,
My lord, the-
you understand, right?
Yes, my lord.
Then
The question here which was failed to be taken into account by the learned single judges, my lord, there was no subdivision of survey number 427. And
no,
before,
madam, the fact that the petitioners were assignees of land and were shown as pattedars has not been disputed by you.
they were not, it's not disputed, my lord, but we are saying that they are in certain land of 427.
Burn. Yes.
My lord, the counter which we have filed before the learned single judge, we do say, my lord, that they are shown as assignees. But in certain land of 427, not in the land.
Therefore, there is a direction to identify the land.
I'm only seeking
If the
for,
land is identified,
Yes,
then
sir.
fine, otherwise pay compensation.
I'm seeking
Or
for some,
alternate land.
some modification of time, my lord, with regards to time. Some more time is granted, we'll come.
That you can grant 2
Yes.
more months time.
Very well.
That's why you started like that, no? Started by saying 2 months, right? Mark the presence.
I'm representing on behalf of the
Heard on
division
the
of
question of-
for respondents.
Heard on IA 1 of 2023. You are appearing for respondents.
Yes, my lords.
Heard on IA 1 of 23. For the reasons assigned in the application, comma, duly supported by an affidavit, comma, we find that sufficient cause for condonation of delay of how many days, madam?
136 days.
36 days in filing the appeal is made out. Accordingly, delay in filing the appeal is condoned. IA is allowed. This intra-court appeal has been filed against an order dated 10th of March 2023 passed by learned single judge, by which writ petition preferred by the respondents has been disposed of. Paragraph. The learned single judge. Paragraph. The respondents stroke petitioners have filed a petition seeking a
Petitioners
what listed.
yes, treated as ineligible for not uploading 9th class bona fides.
Why don't you do it 26/7/23? You have been declared ineligible. Now, after when? Today is what?
Today is 21st or 6th.
You are waiting for 2 months to complete, right?
Lordship,
And
the
then
petitioners, that they are from rural background, Lordship, they don't know. I can't come on, but she is delayed, Lordship, but one submission, Lordship, phase 2 of the PDS counseling has not yet commenced. They can consider, Lordship. It is only not submitted.
Why? But why you did not, these timelines are fixed for everyone. Why a special treatment to you?
Lordship, I'm not.
Oh, it's up to Mr. Rao. If he says he can do it, he can do it.
But
This court will have,
But one submission, Lord.
will you?
Daily from Arbitration, it will be a progress certificate from Telangana, published, and inquiry, it will get certification, they were debarred. After time, directly, it was considered.
Lordship, one sub.
They will consider.
This law is not about local, non-local, it's about the not submitting my, Lordship, they accept 10th class, Lordship, page 14, Lordship, for
Eh,
it.
we will not accept. I mean, this is the most we can do for you. Consider.
Lordship, one submission, Lordship, I not take much shit, page 49, Lordships, the bona fide certificate for 9th.
No, Mr. If you want us to pass an order on merits, please explain. 26/7/2023, you were declared ineligible. Why have you come after nearly 2 months? Number one, delay. Explain the delay. Then secondly, what is the reason for non-furnishing? It is not their fault that you did not furnish.
Lordship,
Why? I mean, we should this thing deviate from the general rule and grant you why?
Lordship, one submission, Lordship, I leave it. Page 49, Lordship, they accept the bona fide certificate. Lordship, they accept bona fide certificate for 10th class, the bona
So
fide.
why you did not furnish, Mr.
Lordship,
And
we have
what were you doing for 2 months?
Lordship, it's the same bona fide certificate, 9th and 10th, same, page 49. They
You have
accept
been declared in, is it your case that despite furnishing, you have been declared ineligible on 26/7?
Lordship, we have furnished all the documents and they have accepted for 10th class, the same bona fide certificate, they're not accepting for 9th class.
Not, Mr. Not acceptance and non-furnishing are two different things.
Lordship,
Please understand the distinction. Non-furnishing and non-acceptance are two different things. You are very conveniently using the,
page 45, we have furnished, Lordship, for a minute. Their own certificate, page 45. It's admission certificate, it is not that we have not submitted. Page class.
find out, Mr. So this case is altogether different. We thought he has not furnished.
You have furnished.
Learned counsel for the petitioner submits, heard on the question of admission, learned counsel for the petitioner submits that even though the petitioner had furnished a residence certificate, yet he bona fide certificate, yet he was declared ineligible on 26/7/2023. It is further submitted that the second round of counseling is scheduled to be held shortly.
Date has not been given.
Let me see the counsel you stand like. So when,
Lordship, date has not been given, Lordship.
Ah.
It is for
so what is the explanation when a query was put to learned counsel for the petitioner? Yes, right. When a query was put to learned counsel for the petitioner that even though the petitioner was declared ineligible, the petitioner filed the writ
options and petitioner is treated as ineligible for.
What is wrong with the rule?
Lordship, I'm not wrong, Lordship. The
You are
submission, what I-
following the rule, right?
Lordship, the submission, what I just want to make before your Lordship says, page 51 is a further notification issued by the registrar for entertaining a fresh registration proceeding in spite of the rule. Lordship, relaxing the condition where the GO numbers 125 says that, for a minute, Lordship, no fresh registrations can be permitted once it is done. Page 19, Lordship. Page 19. No fresh registrations are permitted after last date of online registration as notified by the university. Lordship, pursuant to this, Lordship,
No, where the rule you are challenging is at page 19A, right?
19A, Lordship, this rule. What is this? 19.1 was relaxed by the university, Lordship, page 51 for a minute. Fresh registrations were considered, Lordship, after last date, Lordship, fresh notification.
Mr. Please read the rule. What is it? You are challenging the validity of a rule without even reading it. What is the rule? If it debars a candidate if he has not exercised the web options in the first phase of counseling, he is debarred from participating in the further round of counseling. What, Mr.?
For that reason, Lordship.
How can, I mean, this is a disabling provision so far as candidate is concerned.
Lordship, here is
What ground it is arbitrary and discriminatory, what like that?
Lordship, for that reason, Lordship, Lordship, the DO says
It must have been upheld some, Mr. Rao, sometime. No, challenging the virus of the provision. No, you find out. I mean, we are not inclined to, we are just asked you. Otherwise, we will write an order right away. We are not convinced. He has not made out any ground of challenging the provision. So what ground you are challenging?
Lordship, for that reason, Lordship, for a minute, if you Lordship grants me a minute. Lordship, page 51 is a further notification was issued by the registrar, Lordship, first 4 lines, Lordship, in continuation of notifications dated so and so, so and so, the can hereby notifies online registrations for new for qualified who have not registered in response to the earlier notifications. Lordship, the government, the registrar has relaxed the condition, first condition of US members number 125 for fresh registration. Lordship, here is the case.
No, for that reason, the rule does not become invalid. For that reason, you can say that the notification should be quashed because it is contrary to the rule. That is understandable.
Lordship, but I can also be treated as fresh candidate for fresh registration. But I am restricted for fresh registration.
No, we will not permit anything which runs contrary to the rule, Mr.
Lordship.
If you are raising a contention that the notification dated 11/9/23 should be quashed because in contravention of the rule, understandable. That is not your case.
Lordship, what my submission is in this other way. When they can relax and they can give.
No. If they can permit others to commit theft, I should also be permitted. This is the relief court of law cannot grant. If Mr. Rao can do it, he can do it. We can't do it.
They always say that
This is like saying,
registrations cannot be permitted.
there is no concept of negative equality in law. Please understand. If others are being this thing granted the benefit, you can very well challenge that this thing we understand. But that is not your case. That this notification dated 11/9/2016 should be quashed because it is in contravention of the rule. That is perfectly understandable. But you cannot say that. We don't know who are the others who are being permitted.
They are not restricting me for fresh. Lordship, I did not opt in web options. Lordship, I have not.
So what is the prayer, Mr.?
Lordship, no, Lordship.
We don't think you have anything.
Lordship, interim prayer, Lordship, allow me to opt for web options. Allow me to opt for web options of next phase of counseling, Lordship.
No, but you have not argued anything about how the rule is arbitrary or this thing. You have challenging the rule just like and not arguing anything. We will dismiss it. We will dismiss the writ petition. No ground has been urged to say that the rule making authority has power to make rules. Or is it your case that it does not have power?
For that, Lordship, page 16 may be taken, Lordship. They say that in the rule is amended for the GORMS number 114, rule 4, subclass 4. Now here it says that candidates are permitted to exercise web options for each round of counseling separately. When they say that I can exercise the web options for each round of separately, now they are putting a restriction clause, Lordship, further amending to it. Without amending to the first rule of GORMS number 114.
Please again, how many times, second time we are telling you, your prayer in the petition is not that the notification dated 11/9/13/23 is contrary to rule. And therefore you are not seeking quashment of notification. We would have understood that.
I'm not,
Then,
not against the notification they issued for.
then we cannot permit. We cannot permit you to participate if you are disentitled under the rules.
But GOMS number 114 says that I can participate, Lordship, permitted to exercise each round separately.
No, whatever rule permits you do it, whatever. Mister, we are concerned. We are not concerned what you can do. You do whatever you can, but we are examining the validity of the rule. How is it bad? Please tell us.
But Lordship, without amending this rule, Lordship, GOMS number 5, they have put a restrictive clause under 125.
Nothing of it. See,
Different is different.
ask him to read. Para 7.
Para 7, please read para 7. From it is necessary, third line.
How do you draft the petitions, mister? And don't even read it. I mean, we are required to make you read in the court. What can be the...
You yourself are saying it is contrary to GOMS 125. Now what has to be decided now?
Lordship, I stated that it has issued contrary
And
to
seeking permission to appear, to this thing permit in, apply you. What is that?
Lordship, that notification is contrary to the GO. I admit, Lordship, that not.
No, you have not argued any ground, mister, for declaring the rule invalid. Yes.
Lordship, I'm not.
Anything else?
I'm not asking for rule to be there, that notification, because so many.
This is the
parties
challenge
will
in
be
the,
affected of that.
mister, this is the,
Notification.
please understand, I mean, you don't even read the prayer clause also of your petition.
But prayer, I challenge the rule, Lordship.
Then you are saying I am not challenging rule.
Notification, Lordship. I'm saying I'm not challenging the notification issued on 11/9. I'm challenging the rule.
Rule. That we will decide. Yes. Anything else? Because you have not argued why the rule is arbitrary and nothing. You have not said that rule making authority has no power to make rules. Nothing. What
Rule
can
is
be
arbitrary.
heard on the
It's
question of
contrary to the GOMS number 114, because that is what I just heard. GOMS number 114 says that I can exercise the office for each round separate. And they are restricting from
which provision?
Lordship, GOMS number 114, Lordships. Page 9.
Page.
Page 17, Lordships. 16D. I'm sorry. 16D. Lord, 16. Candidates are permitted to exercise.
One minute. Where are 16D?
Small Roman form. Candidates are permitted to exercise web options for each round of counseling separately. So,
No, that refers to candidates who are eligible to participate. Doesn't mean.
I'm eligible.
All right, fine.
I'm not that I'm ineligible, Lordship.
That rule, small rule, formula operates in different situation. This rule, this operates different situation. There you are the candidates of the exercise web options. The candidates who are given admission, if you fail to take admission, they are debarred from further round of counseling. This is a different one.
No, and this rule, this 4 at 16D applies where they have exercised the web option but are not allotted seat. Then again,
they can participate in. But the candidate is allotted a seat.
If candidate is allotted a seat, I can go for a sliding, or I may not. I can have a PA.
yes, mark the presence. You are NEET aspirant UG course, right? Undergraduate course. Yes, ma'am. Petitioner who is an aspirant getting this order right. We will have to hear, instead of granting stay every day.
Unfortunately, it's being listed.
Unfortunate.
In fact, it's all filed on one day.
Done it, same order. Yes.
I'm obliged.
How many cases now?
No, it's not over.
Last, stop. Cash crop is over, right?
Waiting for us.
List, the same order, list along with WP number 25875 bar 2023 for an August hearing. Yes.
I'm obliged.
May I please? My grievance is, my lord, in spite of paying entire loan amount, my property was sold. My lord, I filed the writ petition. Writ petition, all through there was stay and disposed the writ petition to avail remedy available before the SURFACE Act, my lord. I filed an appeal along with the delay petition. The tribunal, my lord, on the ground, the tribunal has jurisdiction to entertain only up to 45 days. He has not considered the pendency of the writ petition and entire amount is paid, my lord. That's the only ground, my lord. He dismissed my.
But you are challenging the order dated 30th/6/23 passed by Debt Recovery Tribunal, correct? Appeal under section 18, Satyavati Tandon, consistent view. You people should now stop arguing for this court. See, we are repeatedly, Calcutta is a nice place, yes.
But
who told you? This order is Satyavati Tandon, 3-judge bench of Honorable Supreme Court. Yes.
Every day I'm seeing, my lord, you are
Yes.
not the order.
That's why we are saying, heard on the question
There
of
are another
admission.
two appeals are all.
Heard on the question of admission in this writ petition, the petitioner has
I'm obliged.
But there are two other appeals, but not numbered. Tomorrow.
please tomorrow.
Same, my lord.
You can give, yes.
My lord, I will.
All
That it will.
May I please, my lords? I am for the petitioner, my lord. In this matter, the senior counsel Madan Mohan sir is appearing, my lord.
No senior counsel. You are senior counsel, right? What is this? Order 7 rule 14 application rejected. You are senior counsel. We will this thing denotify if he appears in order 7 rule 14 and doesn't permit you to argue. What is this? Why it should not be taken on record, Mr. Tell us. What is the prejudice? Nothing. This all it should be. Otherwise, no. If this order is allowed to stand at the appellate stage, he will file an application under order 41 rule 27 and the appellate court will remand. What is this? You shouldn't even oppose. Yes. That we will never do, Mr. That we will never say that you conceded. Yes. In this, with consent of the parties, the matter is heard finally. In this writ petition under Article 227.
Evidence, my lords. I am not.
Before evidence? Before evidence he had filed? Admittedly, the petitioners had filed an application seeking production of documents before evidence, full stop, in order to afford an opportunity of hearing, opportunity of fair and just trial to the petitioners, the trial court ought to have allowed the application under Order 7, Rule 14 of the Code of Civil Procedure. Marking it, of course, obviously, you will, there's no question of observing. This is only Order 7, Rule 14. That does not no, not necessary. That trial court will take care of.
Deeply obliged.
You know that, right? You will tell the trial court. Yes. Next. Yes.
Because I am appearing in 10. 10 may not survive if your lordships take a decision in 11. If your lordship may kindly hear the 11, the item number 11 first.
Yeah.
I'm appealing for petition in item number 11, madam. We have already.
Last time you had granted time to file counter somebody.
Rejoinder, madam.
Fine. All right. What is to be done, Mr.?
In 11, my lord, I'm requesting time, my lord, as senior counsel Elder Vichandu sir is appearing in this matter. Anytime next week, my lord. He is not available in the city today, my lord.
Item you appear for?
Item 11.
Which respondent, Mr.?
Petitioner, sir.
Petitioner. Learned counsel for petitioner in item 11. Praise for short accommodation on the ground. What's your name? Right.
Mayur Mundra.
On the ground that the arguing counsel, Mr.
Elder Vichandu
is not available. Senior counsel. One minute. So we will have it on 10th instead, 9th instead of 9th. 10th. 10th.
Nice.
October. Yes. Yes, next. Ah, yes.
May it please be true. The stay petition is for stay of recovery of demand and
We want to hear you like on this question itself. What is prima facie? Yes.
just a short note on that.
Yes.
Just one up. Lots.
Not stay. We are asking you to argue itself. We will decide it. If you are ready, or you can argue on Saturday if you want.
Yes.
Hmm?
Actually, this time limit given expires today for payment.
No, we are ready to hear today itself, but what we are, instead of arguing on stay, please argue finally.
I'm
You are
obliged.
ready.
I'm obliged. Milord may kindly refer to the synopsis I gave at the time.
This one.
No, on 29th August, Milords were kind enough to
No,
admit
no.
this
So,
appeal.
see, Mr. The facts are that a complaint was filed on 12/7/2017 against you,
Yes,
right?
in fact,
Alleging violation of the FEMA Act, right?
section 6.
And the section
6,
63B was omitted on 15/10/1999.
Yes.
And your submission is that this
Appealed order
was show cause notice was issued thereafter, and therefore it is without jurisdiction.
yes, following Royal accommodation.
And this thing, this is the main submission that section 63B has been omitted with effect from 15/10/1999. Therefore, the proceeding which culminated into passing of the order dated 4th of January 23 is without jurisdiction, and you cannot be relegated to the alternative remedy of appeal.
Exactly.
Your case falls under one of the exceptions to Whirlpool.
And the learned single judge held that the first respondent had jurisdiction to pass the order. That is why.
No, but we can, if you are aggrieved to that extent, we can keep that issue open. That notwithstanding notwithstanding that finding, it is open for you to raise in appeal this ground that the authority had no jurisdiction.
But
if that you want, we can do that.
I'm challenging the assumption of jurisdiction itself.
Yes,
continuing it.
Then necessarily we will have to give an opinion whether or not the authority had jurisdiction. Then you cannot say that the court has relegated you to an alternative remedy.
May I request Milord, then Milord may kindly take it day after tomorrow so that I would prepare. No.
That's why we told you.
Just to assist Milord, I am prepared to.
Saturday.
Just to assist Milord with a proper synopsis.
Saturday. We have a working Saturday.
Yes, Milord.
Right? It would be an ideal day on Saturday.
Yes, Milord.
Let the appeal be listed for final disposal. Like, let the appeal be listed on 23rd September 2020.
Yes, Milord.
Yes, next.
Right, Lordship, I am representing on behalf of respondent, madam, coming for counter, madam. Lordship, kindly grant time counter. That's the process of motions has been initiated in order to
Reddy, law clerk.
from tomorrow they are giving the web options.
1 minute. You are seeking stay of a statutory
Yes,
provision. What?
Let them file the counter. At their own time, but meanwhile I deny my constitutional right.
Constitutional right?
Yes,
What is the constitutional right?
equal opportunity in public employment.
You are claiming promotion, right?
Yes.
To the post of headmaster.
Headmaster grade 2, Mr. Yes.
And you have challenged this thing,
Proceedings.
GOMS dated 23rd January 23.
Yes.
What is it?
In
What
GO
ground?
number 3, that's the petitioners are working.
By this GOMS statutory rules are framed, right? Where is Mr. Reddy? Rahul Reddy. Law clerk. Inform. Yes. Yes.
The petitioners are working.
The rules have been framed, right? By this GOMS 23rd January 23.
GOMS number 3 minutes.
There is an amendment to the rules.
Yes, sir.
You are challenging that amendment. 1 minute. Let us understand, because you are not arguing, right? So you are challenging the amendment to the rules, and you want, by way of interim relief, stay of amendment. Why? When, what circumstances a provision, statutory provision is stayed by the court? Any idea?
Yeah. For instance, a person appoints under TSC 2001 in one district floods. He was promoted in 2003 as a school assistant.
For grant stay.
In the same anomaly, the another person appoints in another district in a GT, they got promotion in 2005.
Now these two persons are inserted into the zonal systems. Then B is becomes a senior, A becomes a junior. That's why this zonal system, the multi-zonal system is denying the right of the petitioners, which is obstructing them to not to get the promotions as the school assistant grade 2, as the headmaster grade 2 members. That's as per the GOMS number 10. That's as per GOMS number 10 belongs. Jilla Parishad school teachers appointment and promotions, what of vacancy, whatever it is, should be taken a district, a revenue district as a unit. By the amending the GOMS number 10, now the proceedings 565.
You have got it listed on a mention memo. We don't. That's it. Anything else?
That's it. Petitioner number 1 is the serial number 69 in the district promotion list. After amending the GOMS number 10, after implementation of the GOMS number 3.
No, Mr. What is, we are asking you why the amendment into the rule should be stayed. You are saying is 65, let it be 68 also. How does it matter? We are asking, your interim prayer is to stay stay the impugned rule.
The apex court clearly said in the judgment of B. Srilata versus state of Telangana.
So moment it is challenged, it should be stayed, right? Apex court said. Where is which paragraph? What is the citation?
Number.
No. What is the citation first?
In the same manner.
No citation, you don't get it. What is citation means? Where it is reported?
Indian court.
Where it is not reported judgment? Citation. Unreported judgment of Supreme Court you are relying. Now what does it say? This is Mr. Incomplete. It is incomplete. Tell him. Please tell him.
This judgment is incomplete. There's no head nor tail, nothing. You have picked up some random paper, observations.
That means you have not even read it, right? It begins on the other end, Learned Additional Advocate General. Whether a judgment begins like this? This is Mr. All. If we write in your praise in the order that this is what you are doing, incomplete, unreported judgment you are citing to mislead the court, what will happen?
I will file it before the.
Nothing. This is thoroughly misconceived prayer. Yes. In this petition, the petitioner has asserted the validity of GOMS number.
Yes.
So, Madam, my lord, the petitioner pursuant to the notification issued by the respondent.
All right, so inadvertently you have filled in the wrong form. And when is the examination going to be held? 30th. Let him appear 30th September. For the post of civil judges.
Yes.
Learned counsel for the petitioner submits that the petitioner has 3 years of practice.
And standing counsel for the respondent.
Learned standing counsel, however, prays for adjournment to enable him to seek instructions and to file counter. In the meanwhile, it is directed that the petitioner shall be permitted to appear in the examination held for recruitment on the post of civil judges on 30th September 2023. However, his result shall not be declared without leave of the court.
Obliged.
Accordingly, IA 1 of 23 is allowed.
File a counter in the.
Madam, my lord, present matters coming up for consideration of interim order, your lordship.
File.
Is on the
Right.
regularization.
There you write one minute. In the previous case, you write no case for grant of stay is made of statutory provision you have written. Even otherwise, it is well settled that without holding the statutory provision constitutionally valid, the court cannot issue a direction not to implement the statutory provision. Therefore, the relief sought, therefore the interim relief sought for by the petitioner can also not be granted. For this reason also cannot be granted. There you have written earlier one sentence now. See so and so, Dhanraj versus Vikram Singh and others, 23 SCC. Yes.
Find a counter in this matter.
Madam, my lord, coming up for consideration for interim orders.
Yes.
There is a challenge to the EO.
Saturday. You have gone through the counter, right?
Yes, my lord.
We'll hear on 23rd. The respondents have marked their presence. Respondents have filed the counter list on 23rd September 23. Yes.
This lordship, seems lordship, the official respondent filed counter in this today.
I have filed today itself. Indeed, along with vacate state petition has been filed by me with.
You have filed counters.
Yes, sir.
Vacate petition.
Vacate petition has
What
been
do you
filed
want?
Official respondent filed counter in this lordship today, lordship. I received papers today itself. Just fine for.
You, so they filed, so you are ready.
Just now received lordship.
Then say so, mister. What do you want? We are second time asking.
That's what request time lordship.
Learned counsel for the appellant prays for adjournment in order to enable him to go through the counter filed on behalf of respondents. List.
Invoice, my deed may be allowed, may not, because.
We will see what is. Yes. List after 1 week. Yes.
Lord, I am petitioner's counsel at number 20.
Yesterday you have adopted the submissions, right?
Yes, madam. These matters.
Nothing he has to argue. 5 and 8.
5 and 6.
6 has to argue. Yes. Who is the counsel for 5 and 6?
The senior counsel will be appearing in virtual.
No, 5 and 6, mister. There was some counsel. Yesterday you have adopted the submissions of
Yes,
made
sir.
by them. Why again you are standing up? It's his fixed for his submissions. Where is he? Show his name 5 and 6.
May I make my submission, my lord? With the leave.
You are appearing for 5 and 6?
Yes, correct. For the council on record for response 5 and 6, my lord.
Yes. All right.
My lord, the respondents 5 and 6 are the beneficiaries or the purchasers of the property, my lord, from the society which is being represented by respondent number 7 and 8. The precise contention of the writ petitioner in the shape of PIL is seeking a mandamus to declare the action of official response 1 to 4 in granting permission to respondents 5 and 6 to make a complex construction over the subject property, which according to writ petitioners, it is a park earmarked in the layout approved way back in the year 1984-85.
It is earmarked as a park.
According to writ petitioner, first it was earmarked as park. Therefore, the allegation of writ petitioner is the respondent number 7 and 8 was appearing as the chairman and secretary of the society called the Indian Airlines Employees Housing Society. Unfortunately, the society is not made as a party in this writ petition, but then the society's representatives were made as parties.
However, you will not give.
Beg pardon, my lord.
No. Yes. Go ahead.
Yes.
So what are your Mr. We will appreciate if you can formulate your submissions and then perhaps elaborate.
Yes.
So what is your first submission?
The first submission is the averments made in the writ petition, can it be a qualified PIL based on the averments?
Averments made in the petition?
Can it be taken as the qualification to entertain application as PIL?
Cannot be taken. In view of averments made in the petition. Petition cannot be entertained as public interest.
Yes.
Yes. That
apart from the writ petition, there were some other writ petitions which were disposed of by this honorable court on different occasions where the similar relief was sought either as withdrawn or as dismissed. There are 2 judgments rendered by this court, which is filed along with my compilation.
Earlier writ petitions were dismissed.
Yes, Pilot. Either one is as withdrawn, another was dismissed.
Seeking. Yes. Next.
The third is the very writ petitioner who claims property in the layout is also abiding by the revised layout.
Who claims property in the layout?
In the revised layout, there are 2 layouts. Initially, the layout was according
to what is the submission that the same writ petitioners claims property in revised layout also?
Yes, Pilot, which is related by the response 5 and 6.
No, so revised layout means it doesn't claim the land on which you are constructing or have constructed.
It's been constructed 2 decades back, not now.
So is he constructing the same? Is he claiming same land on which you have raised construction?
No, my lord.
Then
he is allotee of one of the plots in the layout approved.
Revised layout.
Personally, there is no dispute among the properties of petitioner and this response 5 and 6. They are distinct different properties.
Allotees of plot in revised layout. So therefore he cannot say that it is forced or something.
He is stopped from questioning the layout.
Stopped from questioning the layout. Yes.
Yes.
What else?
Well, it per se to the statements made by the official respondents, it is apparent that a number of constructions which are made on this layout is in accordance to revised layout only, not only the subject property. Therefore, my lord, the revised layout is in principle ratified and accepted by all the parties, including petitioner and the authorities. My lords, when the revised layout stands unquestionable, the property which is acquired by the response 5 and 6 under registered sale deed way back in 1996 and constructed the commercial complex in accordance to sanction given by GHMC would stand appreciable, cannot be questioned. That would be my precise approach. I would elaborate on these aspects.
Yeah, what revised layout has been ratified, and what is the next last submission which you made?
When the constructions have come up in accordance to revised layout all over the plots, including the subject property, the inference is drawn. In principle, it is being accepted by everybody, and at this belated juncture, there can't be any raise by this petition, much less in the shape of PL, to say that there is no such revised layout. And only the provisional, the first layout has to be accepted, in which the subject property is earmarked as park. But that would be a no more better place.
Yes.
No, Millet. May I take my notes to the...
Yes, please.
In the present writ petition, which is item number 19, writ petition number 12538 of 99, Millet, for the sake of convenience, a compilation be placed by the advocate on record. May I request my lords to peruse from the compilation submitted by response 5 and 6, Millet, which is being circulated to everybody on record.
Yes.
It's a compilation booklet, Millet.
Yes. It begins with some death certificate.
No, Millet, the compilation starts with a memo, which is dated 11/9/2023, Millet. I'm sorry, Millet.
All right. No. Yes. Memo. 19/9/2023, right?
11/9/23, Millet. It was given with SR number 89039 of 2023, Millet.
19th September, right? It is dated 19th September.
No, Millet, it is 11 September 2023, Millet.
11 September. Madam, so this is something else.
Millet, this compilation is a booklet, Millet, consisting of about 300 pages.
Oh, yes.
Yes,
Yellow and green thing, right?
Yes, Millet. Yes,
yes.
I'm deeply obliged for
Yes.
I'm deeply obliged.
Yes, please.
Millet, in this first writ petition, the counter affidavit of respondent number 2
Counter affidavit
of respondent 2 would come at page number 13, Millet.
Yes.
Respondent 2 is the housing board, who is the crucial person to articulate between the beneficiaries and the Huda and the government. The contention of this housing board in one line at paragraph number 6, which would come at page 14. May take me to paragraph 5 also to have the clarity, Millet. 5 and 6 at page 14.
Yes.
Housing board says it is submitted that the counter affidavit was filed on behalf of this respondent in the connected WP number 25738 of 97. I crave leave of this honorable court to read the contents of counter affidavit in WP number 25738 of 97 as part and parcel of this counter affidavit to avoid repetition. I will go to the other amendments, but then the crucial would be paragraph number 6. What it says, as regards the allegations made in para number 5 of the affidavit, it may be true that the MIG 64 could have been allotted to the petitioner. Let the petitioner contends in the writ petition that he is owner of this plot house number MIG B64, which is allotted to him by the second respondent. That is the contention of writ petitioner, and it is being passed on by the second respondent to the writ petitioner. But Housing Board says in the next line, however, as per the records, the Housing Board did not execute the sale deed on 22/6/1996 in favor of the petitioner. The fact remains, Huda is only an articulative person with that of the society, which is not made as party in this writ petition, which is being represented by respondents 7 and 8 as chairman and secretary. The government made the allocated land for the society, which would be mediated by this APHP Housing Board under the approvals made by Huda as layout. But contention of writ petition, he got the property, his property, from the second respondent, which is not correct. Therefore, Huda is not the vendor. Vendor is the society, which is represented by respondents 7 and 8. Well, the 7 and 8 are executants of the documents for a petitioner as well as for this respondent 5 and 6. There is no difference between the executants of the sale deeds to the petitioner as well as this respondent 5 and 6. It's a common vendor. In the counter affidavit of
we told them that we will not go into the question of validity of the sale deed. We have told them SP Anand's case prohibits us from doing so. And they were trying to, we will not go into, you need not labor on this aspect because we will not go into the question of validity of the sale deed. We have made it clear to counsel for petitioners also. Right, SP Anand. So now the only thing is whether in contravention of its use indicated an area earmarked for park has been, this thing, you have utilized it for the purpose of constructing a commercial complex.
Yes, my lord.
That's the only.
Yes, but the revised layout which is being relied even for the petitioner is of 1987, my lord. And the layout which is relying by the petitioner, the writ petition is of 1984, which is a tentative layout or the layout meant for approval.
When was the first layout? Initial layout?
1984, my lord.
And revised layout?
Revised layout of 1987, my lord.
Yes.
1987.
Yes.
And my sale deeds of 1996, my lord. In fact, the sale deeds of every member of society is running from 1995, 96, 97, 98 onwards. Therefore, my lord, all these executions or the sale deeds were made in consequent revised layout, following that revised layout only.
Yes.
But the allegation of writ petitioner is there is some collusion among Housing Board or Huda or GHMC, and they help these respondent numbers 5 and 6 in getting the permission for which the respondent 7 and 8 are unauthorized to mediate. The fact remains 7 and 8 are the persons who will transfer the property to every member, including petition, this respondent 5 and 6. And GHMC had accorded permission in accordance with its own bylaws. However, there might be a rider that in the event of any suppression of facts or misrepresentation that could be recalled, which I am not denying.
What?
Corporation has every right to recall its sanctions or permissions granted to individuals whenever it notices the suppression or misrepresentation of facts, my lord, before it.
Of course.
But here, where is the scope for this respondent number 5 and 6, or the persons who are representing society like 7 and 8 to misrepresent the facts when there is layout in existence from 1987 itself?
No, you please tell us that in the layout, this area was marked for construction of shops and it has been put to use in accordance with the layout. That's it.
Yes, my lord. In the
Because,
earlier
see,
application,
because AP Housing Board and everybody else is saying that there is a tempering and it was earmarked for the purposes of park. Right? So
Therefore,
please tell us that you have put the land to its use as per its use earmarked use in the development plan or the layout.
that this point was raised on the earlier occasion also. Therefore, this honorable court has appointed an inquiry officer in this regard, my lord.
Which writ petition you said one petition was filed and it was dismissed and another one was withdrawn, which
In the present writ petition, which is remitted now.
No, you said, you told us that two earlier writ petitions were filed. One was dismissed, claiming same relief, and another one was withdrawn.
Yes, ma'am. That is at page number 141, my lord.
141
Yes, ma'am.
of your paper book, right?
Yes, my lord. Yes, ma'am. Yes, ma'am.
This is WP number
17494 of 1997. That this is the application writ petition filed by one Mr. Muralidhar Rao, who is a colleague of the present writ petitioner also, and that was filed against 5 respondents. The relief sought in this writ petition is from 4th line of this prayer, my lord. Writ of mandamus declared that the permit number 50/49 of 96 granted in favor of 5th respondent Raghuram Reddy by the 1st respondent Municipal Corporation of Hyderabad in file number 10/TP7/CCP/96 in respect of park area in the same subject property. Park area in survey number 194/11, 5 lands, Begumpet, Secunderabad, as illegal and set aside the same and direct the respondent to demolish all the illegal structures raised in the park area by Raghuram Reddy and Messrs. Integraph, and also direct the MCH of Hyderabad, Huda and the AP Housing Board to develop the park for the use of residents of Indian Airlines Employees Colony, Vaiga lands. But for the same subject properties for the writ filed. And unfortunately, the fact remains it is the present writ petitioner who is articulating in getting filed different writ petitions. That is being demonstrated from the order of this. The order would start in the bottom of this. What happened when neither the petitioner was present before the court, nor any such existing person was there, though it was taken as PIL again, PAL. That oral order is, it is a case where the existence of the petitioner itself has become doubtful. Obviously.
What happened to this petition?
Last 3-4 lines, of the same page, dismissed. That was dismissed,
Oral order, existence, all it.
It is the case where the existence of the petitioner itself has become doubtful. Obviously, somebody appears to have utilized the name of the petitioner for filing the writ petition in question. In the counter affidavit filed by the contesting respondents, it is stated in categorical terms that there is no person by name Muralidhar Rao, son of Dayakar, in the Indian Airlines Colony, Begumpet. It is further stated that there is no such house number 1-8-850 in the Indian Airlines Colony, Begumpet. Obviously, the petitioner appears to be a fictitious one. The Law Counsel for the petitioner was instructed to see that the petitioner is personally present in the court. The Law Counsel for the petitioner, consequent upon such direction, issued notice to the petitioner under registered post acknowledgement due, but the postal covers are returned with an endorsement that there is no such person and there is no such address as house number 1-8-850. The postal covers sent by the court under registered post acknowledgement due are also returned with the same endorsement that there is such house number and such person. In the circumstances, the conclusion is inescapable that some unsocial person used the name.
Mr. Senior Reddy, you will agree there is no adjudication on merits, right?
Absolutely.
Therefore,
Therefore,
if you are trying to raise the contention of res judicata, it will not apply. Yes.
No, I'm not doing that. It's only to demonstrate the conduct of the petitioner and his sailors.
But the petitioner, whether it has been found that the petitioner filed the petition in name of Mr. Muralidhar Rao.
My contention is this is the petitioner present. Writ petitioner is the one who is steering to get filed these type of writ petitions only against this response 5 and 6, not against others.
In this case, identity of the petitioner who had filed the public interest litigation was not established. Therefore, petition was dismissed, right?
True. No, without an education, I admit my for that.
And next case, what is the other one petition you said?
Page 152, my legs.
152. Page 1. Yes.
Now that writ petition number 2965 of 1998.
Yes.
The relevant would be from page 154 as to what is the relief sought by the writ petitioner therein.
Yes.
Well, writ of mandamus declaring the action of the respondents herein in allowing the respondents 5 to 7 herein to construct commercial complex on the site situated in survey number 184 by 11 Begumpet, which is earmarked for park, public park, by issuing proceedings wide file number so and so 3/1/1997. This is permission granted by the corporation. On the file of second respondent herein as highly illegal, arbitrary, violative of Article 14 the Constitution of India, with a consequential direction to the respondents herein to demolish all illegal structures raised in the above said survey number, with a further direction to the respondent numbers 2 and 3 herein to develop park in the sites already earmarked and also directed for prosecution of all the persons concerned and responsible for the illegal construction. The order would be at page 155. Of course, it is also
withdrawn.
Adjudication. It is also not complete adjudication, my lord.
All right, yes.
The learned counsel for the petition.
Mr. But one of the, Mr. Senior Counsel, you will appreciate one of the tasks before you is to meet the reasonings given by a division bench of this court on an earlier occasion. Though technically the order is not in existence, it has been set aside by Honorable Supreme Court on that because parties agree for a fresh hearing, but nonetheless, you will have to meet the reasonings recorded by the earlier division bench.
Yes.
So these two petitions, one was one was dismissed, the other one was withdrawn, seeking the same relief. This is your submission. And the petitioner is getting these petitions filed.
Yes, time and again.
Oh.
My lord is aware that once PIL is taken up on record, the petitioner would be only the informant to the honorable.
Yes.
He cannot
he loses the locus. That's what we want. I mean, we want your submission to be heard by all counsels who are filing public interest litigations. They pursue it as if it's their own this thing.
Personal interest.
Personal interest and fight it out like this thing, court slip and everything. They forget that their role is over once the cause is brought to the notice of this court. Yes.
In fact, by virtue of making application before my lords by way of PIL, they would be status getting only informant but not the prosecutor or thereon. He is only informant to the court and it's for the court to make it. So here, in the most of the times, my lord, petitioner personal interest is being shielded and had come up in the shape of PILs.
Yes.
In the present case also, my lord, unfortunately, the granting authorities Huda for the layouts. Here, Huda has not appeared in this writ petition and did not file counter. It's deliberately, I say. Huda did not file. Is the right person to speak whether the layout relied by the writ petition is to be considered or the revised layout has to be considered. That point to be answered properly by Huda, who is the competent authority. But unfortunately for the response 5 and 6, they kept silence. However, a counter is being filed in the other writ petition, Milad. That is the writ petition number 25738, which is item number 20. In the item number 20, the Huda has filed counter, and that counter would be at page number 247, my lords. Page 247 is the counter in the other writ petition filed by Huda, who is the authority to grant layouts or revise layouts.
Yes.
We'll add paragraph number 3 at page 247. It is submitted that the Hyderabad Urban Development Authority granted layout permission for Indian Airlines Employees Housing Society situated in survey number 194 by 11 of Begumpet wide LP number 2/85 by PT-1 Huda on kept blank. That is 1984. That's the reason why we are saying 84. While granting layout, the authority had shown the open spaces in 6 blocks. So this is the first tentative layout which was granted by Huda, which is relied by the writ petitioner. And there are 6 blocks earmarked for common other usages, different usages. What are they? They have been said continuously. Subsequently, in the report made by some of the employees that there are certain encroachments into the land of the office of the authority, inspected the site and found certain encroachments in open land. The authority immediately addressed a letter in July 1997 to the Municipal Corporation of Hyderabad, mentioning about the encroachments and call for to furnish remarks on the said encroachment in the layout to take further action. Accordingly, the inspection report, the following are the encroachments made onto this open land. Now, there are 6 blocks open in the first layout. On that 6 blocks, these are the encroachments according to the Huda. That is pocket 1, first block, which is subject matter of the present writ petition melody. This pocket 1, which is being defined in the counter, is the present subject matter. What it says, the construction of commercial building is completed with the framework for cellar floor and pillars raised for ground floor. The site in charge of the said commercial complex has informed that the permission was granted by MCH. So the construction which is made by 5 and 6 of the subject property, according to Huda, it is encroachment. Well, this is the counter which is filed in the year 1997. But by then I have taken the permission from DHMC, which they are accepting, but then that permission will be subject to recall, which is the second part. The second pocket is 2 MIG quarters are existing in the part of open land reserved for park and community hall in the approved layout, and also there is a shelter and electric transformer. But all the 6 blocks which were meant for common areas being encroached according to the Huda. It has so happened, Milad, this layout is being revived. That is the
Where are you reading? You first read at page 248, right?
Yes,
He has not received any information, and the competent authority to demolish illegal is municipal corporation. Thereafter, where have you read?
Milad, in the top of this 248, pocket 1.
248.
248, 248.
Pocket 1. Yes.
Yes, pocket 1.
Yes, yes.
This is with regard to the present subject matter, subject property, which is over which the respondents 5 and 6 made construction. What Huda says, the construction of commercial building is completed with the framework for cellar floor and pillars raised for ground floor. The site in charge of the said commercial complex has informed that the permission was granted by MCH. Now, this is one property. There are 6 properties similarly in the approved layout of 1984. Those 6 are number 2 to 6 pockets, which are mentioned below. Fortunately or unfortunately, this writ petitioner who wanted to make this as per the welfare of public didn't question these 2 to 6 pockets, the encroachments which were made. I'm not taking advantage of that non-questioning melody, but then to demonstrate the conduct of the writ petitioner, had this been the interest of public, all these encroachments as leveled at pocket number 2 to 6 would have been raised. At pocket number 2, 2 MIG quarters are existing in the part of open land reserved for park and community hall in the approved layout, and also there is a shelter and electric transformer. That is pocket number 2, which is meant open place. And pocket number 3, 2 old residential houses are existing in the open land reserved for park in the approved layout. Pocket number 4, there is 1 workshop of Messrs. Mohan Electrical Works covered in the part of open land and part of the road in the approved layout. Now, these things have so happened. By the time of counter filed by Huda, these are in existence for the reason it is being revived. Layout has been revived in 1987 itself. Therefore, there is variation between the layout which is being relied by the writ petitioner of 1984 and the layout which is to be accepted of 1987. Now we'll see where from this 1987 layout has been raised. Like to say that there is a layout of 1987 to eliminate the doubt which is being created as to which one is the prevailing either of 1984 or 1987. Now, this court has ordered for an inquiry in the earlier process. That report is still part of the court record now. That report which is where the additional chief judge of Secunderabad is appointed as the inquiry officer and directed to furnish the report on this discrepancy, whether the park is subsisting or the layout privately granted is subsisting or the subsequent layout of 87 would be valid. But on this minute, the report has been, after conducting detailed inquiry, a trial has been conducted by additional chief judge and furnished the report, which would be at page 157 of this compilation. I'll say page 157 is the report. Well, it starts like this, the inquiry report.
Yes.
The Honorable High Court of AP in WP number 12538 of 99 and 25738 of 1997, well, the present item numbers 19 and 20. We pleased to pass an order dated 1/8/2000 directing this court for conducting an inquiry on the point as to whether the site in dispute was earmarked for park in the layout. That was the assignment given to the additional chief judge civil court Secunderabad to ascertain by this honorable court. The parties were directed to appear and they have filed their respective statements and evidences were reduced when documents were exhibited. Having considered all the pleadings set out by all the parties, that the court has made an observation which would start from page number 184, my lord. The point which is considered by the additional chief judge as part of inquiry would start from page 184.
Yes.
At paragraph number 33 at 184. My lords, but there is some visibility is less on this numbering. I'm sorry for that. Paragraph 33. The point to be decided as per the directions of the Honorable High Court of AP is as to whether the site in dispute was earmarked for park in the layout in question. Paragraph 34 starts like this, my lord. Practically, there is no dispute with regard to fact that the site in dispute was earmarked for park in the original proposed layout. It was originally proposed layout, my lord. Exhibit B5 is the sketch pertaining to proposed layout plan of the year 1984, which is the report is still depending on. This is the original plan. In this plan, the dispute site is identified as ABCD and it is noted as park. As already noted, it is everybody's case that in the beginning, in the year 1984 proposed layout plan, the disputed site was earmarked as park. It would not be with if I say the site in dispute was earmarked for park in the year 1984 in the layout in question. In the light of the subsequent developments and the contents of the rival parties, I will discuss the contentions and controversies in the paragraph to follow. A lengthy investigation was made. 4 witnesses were examined. The writ petition was examined as PW1 and RW1 to RW3 were examined. The index of witnesses examined also there at the end of this, which would be at page number 202. This would demonstrate as to how many witnesses were examined while giving opportunity to the petitioner also, writ petitioner also. Page 202 would reveal the witnesses who were examined and the exhibit documents which were exhibited. It has gone as if like a civil suit trial. The PW1 who is appearing at page 202 is the second petitioner in the second writ petition. And the RW1 to RW3 are the officers of housing board as well as the secretary of the society and one of the respondents out of 5 and 6. But here the exhibit B1 on the same page is the revised layout which is being depended by this 5 and 6. Now that revised layout is in question whether it is genuine or tampered. Fact remains exhibit B5 which is slated here on this page 202 is not in dispute. Well, that was the first layout proposed. But it's being followed by a consequential revised layout at the exhibit B1. That this exhibit B1 is challenged or being alleged by the writ petitioner as it is done by impersonation or making various allegations against that it is being forged, tampered, etc., etc. And number of disqualification have been raised onto this exhibit B1. Like this exhibit B1 is supposed to be in the custody of either the respondent number 3 Huda or respondent number 2. And of course, a copy will be marked to GHMC also respondent number 4. The observations made by this inquiry officer is at page number, conclusion at page number 36.
Where is this order dated 1/8/2000? 1/8. Must be there. Yes.
It's page number 201. Yes, page. I'm sorry, it starts at 157, my lord. 157, 18th August 2001.
No, this is the report, right?
Yes, my lord. The conclusion of this report.
What has been found in this report? That it is not tempered.
Yes, my lord. May I take my loss to the page number 201? That is the conclusion of the report. Page 201, my lords. One paragraph.
Yes.
That paragraph 56 would be at page 201.
Yes.
Consequent upon the discussion, from paragraph number 34 onwards, it is being discussed. But the flavor of all these paragraphs from 34 to 55 is precise in last paragraph 56. What it says, consequent upon the above discussion, I as the inquiry officer hold that there is absolutely no material on record to show that the site in dispute was still retained as park in the layout in question. After the revision of layout under exhibit B47 dated 10/4/1987. Of course, prior thereto, it was shown as park in the original proposed layout exhibit B5. Like now the validity of exhibit B5.
Yes.
The validity of this exhibit B5 would be no more relevance in view of exhibit B1 and B47. That is the revised layout plan which was issued on 10/4/1987. Now all the constructions made in this layout for this entire 12 acres which is obtained by the society is in accordance to 10/4/1987 layout only, permission approval only. Otherwise, we'll add as submitted counter by Huda in the other writ petition, there wouldn't have been such an encroachment. They are not encroachments, they all are purchasers. Two aspects to be asserted by now. If truly they were the encroachments, and the writ petitioner is so socially responsible that he wanted to see that no encroachments or violations from the public areas to be made for private utilities. If such is the case, all the 5 or 6 slots with all the 6 blocks which were enumerated in the previous layout of 1984, they all should be utilized for these purposes, for the relevant purposes. Why the writ petition is so serious only against respondent number 5 and 6 of subject matter, which is pocket number 1? Had he been fair to the entire process, he should have raised this dispute even with regard to pocket numbers 2 to 6 as referred by the Huda in this counter affidavit. Therefore, this choosing process by the petitioner would demonstrate that it is his personal interest, not as a PIL. Had he been pursuing this in the interest of public, then the process should have gone for all the 6 pockets which is being divested for other purposes, then that of meant in the approved layout of 1st 1984. As a matter of fact, my lord, the so-called first layout of 1984 is no more in emergence. It is there in 1987 merge. 87 is prevailing.
How many shops have you constructed? How many shops have you constructed?
My lord, it is a complex concept, ground plus 3 floors, my lord.
How many shops you have?
It is whole 3 Indias in accordance to permission given by JHMC, shops are constructed, my lord. It is a big shop mall, like.
It's a shopping mall, right?
Shops, my lord, and it has got offices like banks, etc. also established in that as by tenants. And not only altogether 600 square yards, it is different shops and offices because it is in different levels, ground plus 3 floors. But those structures were in accordance to GFM's approvals. But in case if you have deviated in such making constructions,
This thing is your sum and substance of the submission is you are placing reliance on an inquiry report to say that in pursuance of an interim order and a detailed inquiry was conducted in which it was found that there is no material to show that this in the revised map, the area on which you have raised the construction of a commercial complex was earmarked for the purposes of park, even though in initial plan it may have been.
Absolutely. Absolutely, that's my precise.
What it's.
In case if 1987 has come into operation, that the structures made by the writ petitioner and all the occupants in the layout are in accordance to 1987 only. Presuming that if this 1987 layout is tampered or manipulated or forged, etc., the other structures in the entire layout, which is almost 159 structures, 159 houses, wouldn't have come into existence.
Yes.
The structures which were raised by these respondents, only after the conversion of land use, that is being done by the very authorities, that is society, respondents 7 and 8 who are steering the society, and they are the answerable persons in getting all these approvals and conversions. To the extent of conversions or approvals sanctioned by the authorities, they may not be in dispute as long as this approved layout is valid, 1987 layout is valid. Now, the other aspect is when the petitioner is intending to have this fact finding, whether such tampering was there, forgery was there, manipulation is there, this fact finding should have gone for a trial court, but under 226 or 227 or any of the provisions in the Constitution, this fact finding may not be that.
No, whether this issue of tampering with the record was there before the inquiry officer.
Yes, he made the all
First additional chief judge.
Yes, everybody presented and they
what is the finding recorded about tampering? There is no tampering.
Millard, may I take to paragraph number 37 onwards, Millard. It is a continuous pages. It is a detailed studies being made, which comes at page 186, Millard. Starts at page 186. Paragraph 37 at page 186, Pallet. There are two paragraph number 37, so they sport at page 186. As this is for the reason at paragraph number 34, point for consideration was started by the inquiry officer, and at paragraph number 36, it is said at page 186, consequently, the point for determination is as to whether there was a revision of the layout on 10/4/1987, and if so, whether the dispute was converted for use of commercial shops. Now, this is being answered as already noted at paragraph 37. The second respondent, APHB, that is the Housing Board, has played a predominant role in the entire episode. Let me first have a glance at the stand taken by them in the statement. They clearly admitted that there is plan on tracing paper signed by their junior housing engineer, district housing engineer, and the regional housing engineer dated 10/4/1987. As a matter of fact, after closure of the inquiry and when the matter has been practically reserved for submitting the report to the Honorable High Court, the Learned Counsel for the second respondent, APHB, filed the tracing paper containing the plan pertaining to revised layout dated 10/4/1987. Earlier, he had filed Exhibit B1, the Xerox copy of this plan on the tracing paper. This court understands that the Learned Counsel for the APHB filed this original plan on the tracing paper to meet the argument of the Learned Counsel for the sixth respondent that this court should draw an adverse inference against the APHB for not producing the original plan lying with the APHB. In fact, the Learned Counsel for the sixth respondent cited quite a number of decisions invoking the provisions of Section 114 of the Indian Evidence Act to draw an adverse inference against the APHB for suppressing the original plan, so that the tracing paper plan has not been given a separate marking, considering the fact that it is an important piece of evidence to decide the issue in controversy. I feel it just to admit the same and discuss about it. However, for convenience sake and for identification purpose, this particular plan is given marking as exhibit B47. 37. I would like to continue to note stand taken up by APHB in their statement. It is pleaded that it is in the revised plan, the site in dispute has been shown as S1 and S2 shops. The copies of the revised layout were also furnished to various authorities by their officials, believing it to be the revised layout. However, it is further added that on a close scrutiny of the plan, it came to light that the said plan was tampered with, and words S1 and S2 shops have been subsequently interpolated. It is further stated that in the reference also there was interpolation with regard to the words shops to numbers. Finally, it is pleaded that by mistake and bona fidely the copies of the said plan were furnished to the authorities on 31/3/1999. Rest of the pleadings are extraneous and irrelevant for the purpose of the present inquiry report. Paragraph number 42, which comes at page 192. May I read the continuation of 38 also, Millet?
Yes, yes.
Yes, Millet. Let me now examine the evidence of RW1, which is the AP Housing Board officer, Millet, executive engineer working in APHB, who gave evidence basing on the record. Even in the chief examination, he admitted that he said the certified exhibit B1 to be true copy on 5/3/99 or 6/3/99. He further stated that when the MCH addressed a letter to their vice chairman to furnish a copy of the approved layout of the year 1987 exhibit B47, his vice chairman discussed the matter with the chief engineer, who in turn issued a memo to him to supply the copy of the layout to the chief city planner of the MCH. This witness further continued his chief examination by stating that after searching for the said plan quite for some time, he could trace out exhibit B47 plan, and after taking the blueprints of the same, supplied a copy of the same to the seventh respondent, Raghurama Reddy, and the representative of the MCH. According to him, exhibit B1 is a Xerox copy of the copy supplied to these persons.
So, Mr. One thing, your stand appears to be, I mean, subject to what you say. As we gather, your stand appears to be that there may be an interpolation, but this original, 1 minute, there may be an interpolation, but it is for them to explain because it was the layout in their possession, not yours. And secondly, you say that in the revised layout plan, it was not earmarked as park. It was earmarked as a commercial space, and therefore you have utilized it, right?
Absolutely.
Huh?
Yes, Millet.
Is this the submission?
Yes, Millet. And as long as this the writ petitioner housing board demonstrate that there was interpolation and the people who indulged in such interpolation has been prosecuted in appropriate forum and they were convicted, as long as that things have not been ascertained, now we cannot presume at this stage that the layouts are interpolated or manufactured. Even if
No, Mr. C, there may be an interpolation, may not be an interpolation, but you say that you seem to suggest that it may not be relevant at this point of time because as per revised layout issued on 10/4/87, the area in this thing has already been earmarked for commercial purposes, correct?
Yes, Millet. Yes, Millet. May I take for a moment, my lord, to paragraph number 42, page 191 also, Millet.
This is what it is, sum and substance of the report. Why to read it? Yes.
Yes,
Next.
yes, Millet.
What is your next submission?
Yes, therefore, Millet, as long as this 1987 is not denied and proved to be incorrect or improper or manipulated, Millet, the sale deeds which were acquired by this respondent numbers 5 and 6 of 1996, which almost a decade later, and the sale deed which I obtained would be specifying the schedule with, that is S1, S2, which is not the park. Percent layout of 1987.
So this stand is substantiated by the inquiry report, right?
Yes, Millet. Yes, Millet.
What else?
Therefore, Millet, the petitioner cannot say that I made construction over the public park. In the absence of there being no public park, and in the absence of any such proof demonstrated to the clarity of everything that this layout is fabricated or manufactured, whatever it is, it cannot be said. That these are all taken the process of gazette notification by the state government as required under law. Having gone through the entire process of conversion of land usage, gazette notifications by the state government, well, at this belated stage, can we go and say that 1987 is forced? Therefore, for two reasons, the petition is basically stopped from making such allegations, having obliged the 1987 layout for other house properties within that layout. Second is, as long as it is not being proved, the third point would probably be in the mind of petitioner, my lord, whether this 1987 layout is
how this report has been dealt with by previous decision of this court in division bench.
Well, the judgment rent.
Get the judgment. No, yesterday we told you.
Yes, it is being submitted in the compilation also as a reported judgment.
So how it has been dealt with, Mr.
Well, there it was said that it was referenced to the master plan. Master plan.
260 is the order.
Yes, my lord. I'm sorry, my lord, that
page
223, my lords.
223.
223. This reported judgment for punishment.
Yes, yes. How this report has been dealt with, you please tell us.
Later. The questions which were tried by the previous in the previous proceeding would be at page number 228, my lord.
235.
228, 228.
No, the Mr. Prabhakar tells us para 34, 235. Is it correct?
We'll go for that, my lord. We'll go for that, my lord. Obviously, we'll take this other part of the appreciation. We will depend on
Para, he says para 26.
26 are the findings. I am going to the findings, my lord.
Yes.
But then what were the questions tried by in the previous process would start from page to page.
No. That's all right. We have earlier date of hearing. We have seen this judgment. What we want to know is that how the report on which you have placed reliance has been dealt with by division bench, because 29.
The much impression.
Para 32.
32 onwards, the appreciation has gone whether it is within the master plan confined or may take my notes paragraph number 32 of this previous judgment, my lord. It is therefore evident that inquiry officer misdirected himself in submitting the report on the basis that the land was not retained as park. Factually, that may be correct. But the question which arises for consideration is not as to whether an open space was not retained as park, but the question which ought to have been posed and answered was as to whether an open space which on his own finding was shown as park could have been converted for any other purposes whatsoever without following a procedure of law. The inquiry officer evidently has failed to pose to himself the right question for the purpose of determining the correct state of affairs so as to enable him to arrive at right conclusion and took into consideration relevant facts which were not germane for deciding the issue and as such evidently misdirected himself in law. His findings as noticed herein before are also self-contradictory. Having regard to the fact that the various litigations are pending, the sole question which would arise for consideration is as to whether in terms of the provisions of the 1956 Act can the board revise the layout approved by HUDA. Now this is the question, the third question which I wanted to demonstrate is writ petition was relying that the revised layout of 1984 was drafted by housing board, not by HUDA, who is competent authority. In the absence of confirmation or approval by HUDA, if layout is being prepared on the own of APHB, can we appreciate? Is it appreciated under the Act that APHB can go for revival of the layout? Well, that was the point which was discussed on the earlier occasion. But then, that is with regard to the competence. The writ petitioner was saying that this is being tampered or interpolated. That those facts would be asserted only by virtue of an inquiry or by virtue of a trial. Now, the competence of the APHB is concerned, my lord. There I am saying the petitioner would be stopped as because he had followed the same layout. I am going totally different footing, my lord, where can he be still allowed to agitate on a point which himself is abiding, which himself is accepting and proceeding. It is not the case of the writ petitioner that his approvals or his plot or his assigned house is not in accordance to 1987 second revised layout. And all the structures which are in existence are also in the revised layout. Well, if such is the case, then the entire property in 159 plots should be revived to this approved layout only. Why only this respondent? Had it been with regard to all the 159 million, then it becomes a public interest. Here, the petitioner has some personal grudge against this respondent, therefore is invoking all this. That could be acted upon, subject to it applies to the entire layout or entire occupants, including the writ petition. Earlier, the competence of housing board was decided in this whether the housing board is competent enough to revive the layout per se to 1956. That was the only adjudication made.
All right.
And
yes.
Therefore, my humble submission, the petitioner is not a right person to make such agitation, having accepted the contents of revised layout. That would be first and the last submission, as because the bill may not be tenable for the qualifications which are asserted by the writ petition, the affidavit, or the other method relied upon.
That's it. Anything else?
That would be sufficient. Anything commanded to clarify, I am available.
All right. Yes, Mr.
But,
you are the real culprit according to getting the petitions filed and.
no, I think.
Yes.
But the petitioner, is an honest litigant. Yes, and genuinely pursuing this litigation.
Not
my friend, pointing out, that 1987 is a genuine layout. But he was giving, the relevancy to the particular date. Now, in the light of the counter filed by APHB, saying that it has been tampered and interpolated, giving a date, to an interpolated map layout, may not be correct. But there cannot be any relevance to a date for a interpolated or a tampered map layout. So that also is anti-date. And the other aspect, which my friend has pointed out, is that the layout, which was the sale deeds which were executed in favor of all the members of the society, are as per the revised layout. That may not be correct. If your lordship were to see the additional papers, which I have filed, at page number 45 and 46, I will only point out the difference between the two maps, two layouts.
Additional papers. Yes.
Because APHB's counter, additional counter in Supreme Court.
Yes.
Para 9, page 45.
Yes.
It total plots, are one type of plot. A plot, is there are about 50 per 9. Then, B plot, about 109. Total, there are 159 plots. Both A and B put together. Para 9,
Yes, yes.
Then, the tampered layout, is pointed out at page 46. The number of plots remain the same, 159. And the only addition is shorts two numbers. So this star was altered. Their plots remain the same, and only part which was earmarked for only plot which was earmarked for park, my lord, was converted for shops. So to say, my lord, that all the sale deeds were as per the revised layout is not correct. All the sale deeds, my lord, were as per the original layout. And only tampering, my lord, is here, 2 shops. And other aspect, my lord, is that which the enquiry officer did not go through, did not, my lord, consider is the fact that whether the land, because the earlier division bench judgment, my lord, reasoning, my lord, would cover that particular aspect. My lord, I need not add anything more to it because it's already addressed, my lord, on that particular issue.
Except case laws, right? You conceded yesterday that this you need to update the.
True, that, my lord, I pass on.
Please pass on.
I will. But, yes. That's the only thing, my lord, because once even the enquiry officer starts with a note, my lord, at para 34 of the enquiry report saying that, my lord, the land was originally earmarked
Now,
as park.
supposing, so Mr. Still, supposing if the shops have been like shopping mall has been constructed in violation of what relief?
My lord,
there are judgments of Supreme Court like Noida, Twin Towers, and Kerala flats.
Okay, they are consistently, my lord, the only thing, my lord, is that
You are not even citing those judgments.
because I pass. Because your lordship would insist on the paragraphing. My lord, I was just pointing out the paragraphs.
Oh, of course. I mean, you need to tell us paragraph, otherwise.
My lord, I'll pass on. I've got the case law.
But you mentioned paragraphs number, right? All latest case laws there.
I'll mention all the paragraph numbers.
Of this thing, Noida.
Yes, my lord,
apart from
I'll pass on.
Twin Towers, there is one more judgment.
My lord, I'll note down, I'll mention the paragraph numbers and pass on. But by 2:30, I'll pass on.
Yes.
That's all.
Anything else? Yes, Mr. Prabhakar.
And the MCH counter, my lord, in the Supreme Court.
No, Mr. You did not. What did he argue? He said that even if the records were in custody of authorities, not in the custody of 7 and 8, if there was tampering, it is for them to explain how it has been done. Even assuming there is a tampering, that it loses significance because subsequently this layout has been revised, and in revised layout, the land is earmarked for commercial purposes.
My lord,
so that he says that even if tampering, not tampering, it's irrelevant.
My lord, that my senior friend would address. And on the aspect, my lord, once the APHP, my lord, doesn't have power. That, my lord, issue my friend did not address. My lord, the APHP does not have power to revise. Notwithstanding the fact, my lord, that APHP is unable to explain with regard to tampering. My lord, the APHP doesn't have power to revise the law.
All right.
Therefore, my lord,
what about you have chosen him only and left everybody else?
My lord,
revised layout, and he said that you have a plot in that revised layout, therefore you are stopped from questioning.
My lord, I have a plot, my lord, if there are encroachments in other areas. My lord, it's always open, my lord, to the...
Why have you chosen him only? And
my lord, there is no personal vendetta, my lord, to this individual, against this particular individual. It's only a earmarked as part, my lord, and we may be aware, he may not be aware with regard to this entire layout. My lord, if there is an encroachment, my lord, the concerned authorities are always at liberty to initiate action.
That's it. You give that.
I'll pass on.
This compilation with paragraphs number. Yes, Mr. Prabhakar.
Here division bench said that permission from Buddha was condition precedent. First layout was sanctioned by the Buddha. Any deviation or alterations can be made only after the sanction is made.
Alteration can be made only by Huda.
By Huda, not because the original permission is also granted by Huda.
Yes.
Now, under the act that stood at that time, under the Urban Areas Act, AP Urban Areas Development Act, Section 14, Section 13.
Which year, Mr. This Act?
This is 1975, AP Urban Areas Development Act 1975.
Section
13 and 14 would be relevant. Application for permission is 14. So such an application was made at that time. So if there is any deviation or alteration, it has to go only from them.
So you're referring to section 14, right?
Section 13 is what it requires every development authority to approach them as soon as maybe after the commencement of this act, where government considers necessary to do so for the purpose of proper development of an urban area or a group of urban areas, may notification declare such a development area. Then, 4. After commencement of this act, no development of land within the development area shall be undertaken or carried out by any person or body, including any department of the government, unless permission for such development has been obtained in writing from the authority in accordance with the provisions of this act.
So who has altered the development plan in this case? Later, who has revised it subsequently? 10/4/87.
Below, according to the housing board, it has not revised it. According to the respondent number 7 and 8, who are the vendors to 4 and 5, it is the housing board officials which gave them this plan, revised plan.
So Huda definitely has not revised.
That's why I wanted to invite your lordship attention. How to find by the Huda? They don't say that they have sanctioned it. On the contrary, they say all these pockets have been misused. Page 247 of this paper booklet which my friend passed on. This booklet, if your lordship looks into. It's not only this part, to that extent my friend is right. Page 247, lordship see.
Yes.
Paragraph 3, my lord. It is submitted that Hyderabad Urban Development Authority granted layout permission for Indian Airlines employees housing society situated in so and so. While granting, the layout authority has shown the open spaces in 6 blocks. Subsequently, on the report made by some of the employees that there are certain encroachments into the land, officers of the authority inspected the site and found certain encroachments in open land. The authority immediately addressed a letter in July 1997 to the Municipal Corporation of Hyderabad mentioned about the encroachments called for to furnish remarks on the said encroachments in the layout to take further action. According to the inspection report, the following are the encroachments made to the open lands. So, pocket number 1 relates to the petitioner. According to the other 2 to 6 are also violations. One thing to say that the other violators have not been penalized, please penalize them. It is another thing to say that since other violators are not penalized, don't penalize me. But that's not the law, at least.
Yes.
So, my friend, of course, obviously, naturally, he will have a grievance because others are let off and I am not paid. This is because it's an eyesore entrance. It's a commercial complex, cellar plus 3 floors. In fact, they have made enough money for the last 25 years. The real point on which the matter is remanded to this court is not addressed by my friend. The point that was raised was in the adjoining layout. Originally, this is under the zoning regulations. This was a residential zone. The adjoining owner of some other premises obtained exemption from Huda for commercial purposes. So it was pointed.
What is the one more this thing? What is the consequence provided by statute in case of violation? Any other this compounding etc.
It is not there. This comes because so far as public areas and parks are concerned, even in case of BDA, as your lordship knows, where it was given for some other public purpose, like a school, the court said no, you can't do it. Parks, so far as parks are concerned, you can't change the. Maybe if it is a sort of a community center.
No provision in this act, right?
No provision in the act. And there can't be such a law that will be opposed again to 21 and 19. So that is it. In fact, the main basis on which the matter was remanded was that in an adjoining land, adjoining property about a few shops away from this, the zoning regulation was relaxed and commercial activity was permitted because originally this is a residential zone. But that is not the case of either of the party at this stage. My friend also has not raised it.
We don't know.
No, these are the, no, that is the additional document.
In the order of demand, I mean, it doesn't, what you are saying is doesn't find place because you have appeared, that's why you know.
That's why your lordship says the order of the Supreme Court is that certain additional documents are filed in the Supreme Court.
Yeah.
So this the Honorable Court said that can be taken back to this court. Anyway, my friend has not addressed it, therefore we need not have to labor on it. That those are the documents which form part of the additional documents filed before the Supreme Court. And one of the reasons for remand was that to look into those documents.
Stifler.
Supertech is the only judgment that is enough.
Supertech.
Supertech would be enough.
Yes.
I asked my friend to pass it on.
You are giving it, it's in your bunch?
Yes. I don't think it is there.
Mark
It's 200 pages, that's why.
Consent to about 100 pages.
That's why I have not.
No, whatever, I mean, you give.
To give a copy separately. That's enough. Supertext.
That will show the seriousness of this issue involved in the this thing.
Supertech will take care of all the matters. I'll pass it.
That's it.
I'll give a Xerox of it.
All right. Mark the
That way I'll say that it's delivered.
arguments heard reserved for delivery of judgment.
Subject leave, my lord.
You keep it on the table.
My lord, I'm the counsel for R7 in this case.
Earlier judgment division bench. It's there in that yellow, that compilation. Yes.
And one fact, my lord, additional counter filed in Supreme Court on behalf of MCH was by the commissioner. So the seriousness of the matter I just pointed.
Supreme Court.
My lord, on behalf of MCH, it was the commissioner who had filed that.
Actually, they not deposed to IAS officers.
Yes.
He made it a point.
Yes.
My lord, I'm the counsel for R7 in this case, Mr. Raghuram Reddy. He was the secretary of the Airline Housing Board. We'd like to submit that we'll be adopting the arguments of the counsel for R6 and R5.
Give that note, this the pages. You are secretary of the society?
Yes, my lord.
R5 and R6, correct?
Yes, ma'am.
Wait, please. Counsel is on record, is out of country or she is in USA. Client has instructed, take no objection from.
Can appear, right?
She can't appear before. I want client has instructed to prepare no objection wakalat from her right to represent.
This is 2008 appeal, Mr.
Yes, your lordship. Personal inconvenience, 4 weeks, your lordship.
No, for.
She's in USA, she can't be
No.
wakalat for me. She's in USA, she can't be wakalat for me.
That doesn't mean that we will continue this thing.
I apologize.
With them. Mr.
She's
No
coming
apology.
in the month of October, your
You can very well appear on behalf of that. Grant.
You argue. What is there? Pass for tomorrow, we will see.
I am not prepared and I don't have the file.
Tomorrow.
Your lordship. 1 week time.
Hey, what is this, Mr.?
I apologize. But
No, the apology doesn't help, right?
Yeah.
What will we do with your apology? What will we tell us? The net result is you have tendered an apology. A 15-year-old case is adjourned. That is the net result.
1 week.
Now, what is this matter about? Let's see. 2000. No, stop. Then you should say this, right? Instead of give a copy of the petition to him also. Let's see, Mr. What is rejecting application for grant of and granting mining lease to fourth respondent. All right. So, madam, for what period you were granted mining lease?
But the lease period expires. It expires in more than once the.
One minute. 1 minute. Who is not entitled?
Should not want that.
No, no, you are arguing both things, right? Period. Have you got parts in it? No, have you got the period? This period needs writing proceeding initial laws in 1980. Respond number 4 was granted up to what time? 15 years. It's page 2. Maximum W 771. Page 12. 770. No, petitioner was granted clarities. It was renewed. It was renewed up to 94. Where release on 15. And we can see the query list. Nothing. See, this is the level of assistance granted to the court, right? We have to look for everything for ourselves and hold that it has become infructuous, right?
Mountain on record was lady or Dr. Page. Doctor has been appearing.
No adjournment, Mr. You, whatever you want to say, except adjournment, everything else, most welcome. Don't be, we are not handicapped, we are. Don't appear then, don't appear. Not on record, we may ask you how you are appearing, then what will you answer? You have done whatever you could, mister. You have done. She has not authorized you to keep on speaking till we agree. Did she tell you that keep on speaking till this thing? Is there any interim order? Interim order issued. She doesn't know.
What is the lease period? You're not saying that.
See, 1610 order of status. The direction is fail to follow this mandatory requirement. Invite application. 1.13 hectares. 12.5 of MC. Listen to that, there is a status. Status. Therefore, she has no idea. Telling us that I don't have the brief. See, we have to cautious in that because it's our order. They will file SLP. and have heard learned counsel for the respondents. AP minor mineral concession rules. AP. That 12.5 of the rules you write AP minor mineral concession rules, right? Arey, madam, not getting rules. AP minor mineral concession rules. Paragraph. Ah, in the ground, in the grounds of, no, you delete this. We have perused the grounds of appeal and have heard learned counsel for respondents. In the grounds of appeal, it has been urged that Rule 12 within bracket capital A of the That is said. Full stop.
Hello? Hello? Okay. which purportedly, my lords, the proceedings were drawn and the position is said to have been taken. That has not been done. That's the observation, my lords. So they had the opportunity. There were directions for production of the records, but that has not been done.
Adverse inference has been drawn.
Yes, page 33, my lords. Not so much, but the learned singer did examine the entire material, my lord, and came to say, as a matter of fact, my lord, position was not taken. That's a matter of fact, my lords, that the assertion, my lord, the single judge did not believe that the state government took position. As a matter of law, my lord, the learned single judge has found lot of, my lords, contraventions of section 10.5 and 10.6, which are preconditions for taking lawfully, my lord, position, according to the Supreme Courts. So, my lords, I really don't object, my lords. I never said, my lord, no to any adjournment request. It's entirely your lordship's place, my lords.
I also mentioned to my friend, my lord, I'm making mention to the court, seeing that there's some inconvenience being caused at my instance. But subject to what your lordship would say, my lord, I'm only requesting some time. Otherwise,
No, we only expect that you will produce the record and not like yes told no that you are despite directions you have not produced the record before.
And earlier, I'm sorry.
Let it not become the occasion to again seek adjournment that record is not there.
I will produce the record. I'll undertake to produce the record, my lord, because
all the new
summon the record in the office.
In appeal, my lord, your lordships may not perhaps, my lord, consider introduction.
Application is what is
on the basis of, my lord, the records that was available before the single judge. And this is an intra-court appeal, my lord, your lordships. I'm not saying that your lordship's jurisdiction in the intra-court appeal, my lord, is any manner restricted, but there are limitations, my lords. It's not like a first appeal, my lord, from a lower court to a superior court, my lord, where there is a hierarchy. It's only an intra-court appeal.
But then I'll proceed, sir. I'll proceed. But what I was just making a request to my lords.
I'm not opposing your request.
I'm request to my lord.
So, all right.
Request on my.
How much? Yes.
My behalf.
So next date, Mr. Srivastav, next date you.
Yes, whenever convenient to.
Tell us. That should be, even if you get it, don't get it, please.
I'll proceed, madam.
Go ahead.
I'm extremely sorry for making.
May I very respectfully, my lord, request for 29th, my lord, because
29th.
It's a Friday. I hope, my lords.
Friday, we sit till 1:30. That's the only this thing problem. We'll have different combinations of 2:30.
Will it be possible in the first half, my lord? Will it be possible to hear us in the first half, my lord? No. Because I don't want to interfere with your lordships.
We can have it on 27th if you want. 27th.
No, my lords, I am already, my lords, I am somewhere out with engagements.
Somewhere first week or somewhere. First week.
First and second week, my lords, again, I am tied up. I'm abroad, my lord, for arbitration and also. So 29th, we may have chance, my lord, we may take.
I'll be ready.
If we are ready, I am ready with my written, my lord, 3 points of submissions, case note, and analysis of the learned single.
But the only thing is that we sit till 1:30. That's the thing. We can fix the matter on 29th also, but
28 is already.
Yes. My lords, in which event, my lords, in case 29th is, may I request for, my lord, 16th, my lord, it's a Monday.
16th. Fine.
And if necessary, we can continue the next day also.
Yes, 16th. Mark the presence.
Again, apologize.
Mr. Whatever inconvenience to him.
But I have also informed my
learned Mr. Ravindra Prasad. Mark the presence, done it so and so, senior counsel. Where is the list one? List, madam, list. Huh? Not there. Probably they have not kept it.
I don't know what is the practice.
Yes, next.
Lord, my learned friend is suggesting me to make a request if possible, my Lord, after the admission, immediately after.
Yes, yes.
Immediately.
It can be, please feel free to mention.
Yes.
Ah.
Grateful. Grateful.
We have the tradition of accommodating outstation councils.
That's it. The lordships have been extremely kind.
No,
Such a honor, my Lord.
both of us belong to an institution which has the high tradition of accommodating outstation lawyers. So that we are following.
Because it's may I say, my Lord, on a personal note, it's such an honor for me, my Lord, to have a chance to appeal for a lordship.
Pleasure is ours.
Deeply.
Thanks. 28. Mr. Prabhakar. What is it?
Two or three dates would be relevant. Admittedly.
Oh, writ petition of the year 2004?
Yes.
Yeah.
For a change, we are reporting reading. Now, 2 or 3 dates would be sufficient. It's a case where, because the respondent has an authority to appoint an arbitrator under the contract.
Sole arbitrator, arbitrary illegal. What happened then?
But what happened is
there is a stay.
There is a stay.
Is there an interim order in this case?
There is an interim order.
Which date? There shall be interim stay. Oh, 31/1/2005. Yes.
Only 2 or 3 dates will be relevant. But originally, the tender was floated.
You are given dates? No.
I have not prepared a note because there are only 4 dates, I think. Sorry, I forgot.
The youngsters associated with you should work, mister. Why should you? That means they don't work. That is 27/5/87.
I'll give the date. I have the dates ready. The tender was accepted on 27/5/1987.
This page 5.
Yes. Then the
What is the tender invited?
That work was commenced on 30th May 1987. But it was completed on 31/3/1990. Date of completion of work. But these are undisputed facts. 31/3/1990. The final bill was prepared on 9/8/1991.
What is the date of completion? 30th May 87.
31/3/1990. The 30th May 87 is the date of commencement of the work.
31/3/1990
is the date of completion of the work.
What is the tender for?
Final bill was prepared on 13/8/91. It's actually 9/8 is the date, but signed on 13/8/91. 1991.
30th August.
13th August, 13.
13th August 91, final bill prepared.
According to them, there is a minus bill of 6,31,733. This is the claim amount. 6,31,000. Now on 21/10/94, there was a letter from respondent number 3 to remit this amount by 21/11/94. Failing which, they will invoke Article 40 of the contract between the parties. That is the arbitration clause.
What 2110, what was it?
21/10/1994, a letter was addressed to us, to the petitioner herein, calling upon him to pay this amount of rupees 6,31,733.
6,31,000.
733 by 21/11/1994.
2111.
1994.
With it
Failing which, they will invoke the arbitration clause in terms of clause 40 of the agreement. The petitioner denied the payment.
Which page is clause 40?
Clause 40. Extracted.
Acha, you submitted this thing reply to this and disputed the claim.
Claim.
Then they appointed arbitrator. When?
No, they kept quiet. They appointed an arbitrator on 24/6/2004.
24/6. Who was appointed?
The responding number 4 here.
1, 2, 3 appointed R4 as an arbitrator.
That was challenged by me primarily on the ground that ex facie the claim is barred. I am putting it on 2 grounds. Merely because you have a power of appointment under the contract. Unless the claim is within the period of limitation, that would be an empty exercise for both of us. It's a public money which would be spending before the arbitrator. The other ground is that by virtue of the amendment to the 1996 Act, the schedule, because he is an officer of the government, he can't be
Amendment to
appointed.
the arbitration, yes.
He can't be appointed as an
Which is that amendment? He can't be appointed.
He can't be appointed. Now, these are the 2 grounds on which I have put. Otherwise, my lordship will say the claim is of 1991. 2004, they appointed arbitrator. The demand is made on 21/10/94. After 10 years, that itself prima facie would show that the explicit
Who appears for Union of India? Yes. What do you say amendment to this thing? Act. When was the amendment?
prospective, they said Schedule 696.
Schedule, the Limitation Act.
Schedule 6.
Section 12(1)(b).
What schedule 1? 6 schedule nothing?
Seventh schedule. Section 5 of section 12. The arbitrator is an employee, consultant, advisor, or has any past or present business relationship with a party. Once he is an employer. Now this was brought about with effect from 2015. 23/10/2015. It would also govern the past contracts.
How?
But,
23/10/2015, right?
if he is appointed today, by virtue of the statutory.
Last may kindly see, clause 112, under schedule 9, part 9, clause 112.
What is the submission, Mr. Kumar? Please tell us. He is saying that it will apply with retrospective effect. Prima facie, we are not inclined to accept this.
That this was considered by a
Supreme Court decision. Yes.
this particular aspects and take.
That it will apply with retrospective effect.
That case, what happened, the tribunal had not commenced. Though the tribunal was appointed prior to that amendment. But they said after the amendment, they can't continue the proceedings.
Page, what paragraph? No, where does it say that amendment to 12.5 applies with retrospective effect?
What should we say? Ineligibility, arbitral tribunal comprising the officers of one of the parties. Ineligible.
Which paragraph?
Head note I'll read, then I'll take your notion.
No, don't read, Mr. So many young people are hearing, they will, if they start reading head note, can we prevent?
No.
Please.
Paragraph 14, not at page 10.
Paragraph 14.
Paragraph 14 and 15. It may be true, may I read? It may be true that the arbitral tribunal stationary purchase committee was constituted as per the agreement entered into between the parties. It is also true that initially said arbitral tribunal was constituted by the High Court in the year 2001. However, thereafter stationary purchase committee arbitral tribunal could not commence the arbitration proceedings. In view of
what are your grounds of challenge? First ground is?
Number 1 is that it's expressly barred by time.
Claim barred by limitation.
Number 2, no doubt the contract empowers.
Which clause of the contract?
The contract empowers employer to appoint an arbitrator. Just because the power is given, that power can't be exercised arbitrarily. Now the arbitrariness I am pointing out here is that you will have to prima facie examine whether they are within time. I am not going to the facts.
Employee cannot be appointed as an arbitrator.
Employee, yes. An officer of the employee cannot be appointed as an arbitrator. Number 2, the exercise of power under clause 40 of the agreement.
Where is that, this thing? Appointing arbitrator?
Appointing the arbitrator. That is at page 17.
17.
24/6/2004. And whereas the said contracts includes an arbitration agreement, right, condition 70 of the IAFW, all disputes between the parties of the contract which are the national CW or any person is by the contract expressed to final and binding shall after return notice.
Yes, Mr. What you find out TK Saha, sole arbitrator.
Now he was replaced by another arbitrator. We have filed an application for amendment that was allowed because he refused. After
thereafter, another arbitrator also appointed. Now, by this time,
No, but there was a stay, right?
Stay. So that nothing is done. The lordships will see their claim also.
No, but can you not raise all these this thing except this thing under section 16?
Facts can be raised.
1 minute. No, apart from this submission that this amendment to 12.5 applies to facts of the case. How, Mr.? You are referring to a judgment.
Yes, that.
Paragraph
14, page 10. It may be true that the earlier arbitrary tribunal, stationary purchase committee was constituted as per the agreement entered into between the parties. It is also true that initially said arbitral tribunal was constituted by the High Court in the year 2001. However, thereafter stationary purchase committee arbitral tribunal could not commence the arbitration proceedings in view of number of proceedings initiated by the appellant. There was a stay granted by the High Court from 4/5/2001 to 24/1/17, and thereafter in the year 2019, the present application was preferred before the High Court invoking section 14 and section 11 and 15 of the Arbitration Act, seeking termination of the mandate of the originally constituted arbitral tribunal and to appoint a new arbitrator. It is also come on record that in between the officers who were members of the stationary purchase committee.
No, Mr. Bakar, what is your submission? I mean, reading these are the facts of that case.
That's why.
So what is the legal proposition that you said that 12.5 applies with retrospective effect?
16. No, because I will have to also show that on facts there is some parity, otherwise may not. As your lordship.
No, so like, I mean, your submission is that 12(5) amendment is with retrospective effect.
Retrospective effect, it would also govern proceedings where the arbitrator is to be appointed today. Now, the situation in this case is, the arbitrator has to be appointed today afresh, even if my writ is dismissed. In which event, they can't now invoke this and appoint their own officer.
No, who is the other one? This person is not there, respond number 4. He said some other,
Under the terms of
another employee.
another employee.
Now, today, lordship may appoint another arbitrator.
They are agreeing independent person.
Now, if an independent agreement is, a person is to be appointed.
Arey, Mr. It's not necessary to contest everything, right? I mean,
I am saying, if an independent agreement arbitrator is to be appointed, they must move under 11(6). Once they move under 11(6), there is a bar for them today. Even at that time, 2004, they'll have to.
No, he is saying that since you are raising this submission, with your consent, any new arbitrator can be appointed.
I would have given a consent if the arbitrator has jurisdiction to entertain claims today. They are time barred. That 11(6), the Supreme Court said will consider. If the explicitly I am able to demonstrate for lordship that the claim is time barred, 11(6) also this court will not appoint. So what this court would not be doing under 11(6), that I can't be conceding today. But that would be an empty exercise for both of us. Instead of, it's a huge, as your lordship knows, the arbitrations are very costly nowadays. The lawyer.
It's a huge amount, right, of 400,000 crores.
Irrespective of the amount.
No, even you are entitled to contest for 10 paisa also, irrespective.
But what happens is.
Same argument will apply for 10 paisa.
With the arbitration.
Yes.
There, whose money it is after all?
Para 16.
Para 16. As observed here and before, the arbitral tribunal stationary purchase committee consisted of officers. Therefore, as per Amendment Act 2015, subsection 5 section 12 read with 7th schedule, all of them have become eligible to become arbitrators and to continue as arbitrators. Section 12 has been amended by Amendment Act 2015 based on recommendation of the Law Commission, which specifically dealt with issues of neutrality of arbitrators. To achieve the main purpose for amending the provision, namely, to provide for neutrality of arbitrators, subsection 5 of 12, subsection 12, based on that notwithstanding any arbitrator, any prior agreement to the contrary, any person whose relationship with parties or counsel or subject matter dispute falls under any of the categories specified in the 7th schedule, he shall be ineligible to be appointed. The appointment would beyond pale of arbitration agreements, empowering the court to appoint such an arbitrator as may be permissible. That would be the effect of non-obstinate clause contained in subsection.
No, that is correct. That is to the effect of 12(5).
That's what.
No, but like, I mean, you are arguing that it will apply with retrospective effect. Where is that proposition?
In this case also, the arbitrator tribunal was appointed prior to the amendment, but they said they can't continue now, and a new arbitrator has to be appointed. That's what this. That's why, I was just trying to. Because in that case, the tribunal has already commenced its proceedings, but then there was a change.
Escape the rival.
1 minute. You let him complete. We are unable to get the submission like the proposition which he is relying upon.
But para 17. It cannot be disputed that in the present case,
I have a copy.
tribunal comprising of
I have a
officers.
copy. Copy of it.
Section 12, read with 7th schedule. Therefore, by operation of law and by amendment in section 12, beginning on statute subsection 5, section 12, read with 7th schedule, the earlier arbitral tribunal stationary purchase committee comprising of the additional secretary, Department of Revenue as president, deputy secretary, Department of Revenue, deputy secretary, General Administration, deputy secretary to government, printing, has lost its mandate. And as such, an arbitral tribunal cannot be permitted to continue. And therefore, a fresh arbitrator has to be appointed as per the Arbitration Act 1996. This is enough. In fact, there they were by office. Then 18, they said a similar question there. In fact, the conclusion at page 20, para 20 and 21. 21 would make it further clear, in addition to what I have read. Even if I agree, my lord, they say may I read para 20 minutes? That would just make the convenience of the court. 20 and 21 would be enough. At page 19, not 19. In view of the above, and for the reasons stated here and above, the impugned judgment and order passed by the High Court is contrary to law laid down by this court in PRF and cited judgments. It is held that the Athlete Tribunal Stationary Purchase Committee comprising of, I'm omitting these designations, has lost its mandate by operation of law in view of section 12(5), read with 7 schedule, and a fresh arbitrator has to be appointed under the provisions of the Arbitration Act 1996. The impugned judgment and order passed by the High Court is therefore unsustainable and deserves to be quashed and set aside. In view of the above and for the reasons stated above, the present appeal succeeds. The impugned judgment passed by the High Court of Madhya Pradesh, passed in Allura paper means by quashed, set aside, and application being AC number filed by the appellant here before the High Court is hereby allowed. It is declared that earlier arbitrary tribunal so and so as members of the ineligible act continue as arbitrator in view of subsection 5, read with 7 schedule of the Arbitration Act, and therefore a fresh arbitrator is to be appointed to adjudicate upon and resolve the dispute between the parties.
Not agreeing. The issue has to be resolved at the stage. What is says allow my petition and delegate to me. Then we also we are going to raise to the integrated so instead of giving even so the the entire plane was it not claimed. So there is a claim is going to ask. No, this, Mr. Prabhakar, as we understand, Supreme Court has not held in nowhere in this judgment that 12(5) amendment is retrospective in operation. On the facts of the case, they have appointed an arbitrator in accordance with the amended provision. This is what the ratio is. Nowhere it has been that whether it operates retrospectively, prospectively, where which paragraph? Nothing.
I think paragraph 20 itself says they have lost their mandate. The Adelaide Tribunal.
This is saying some
operation.
one sentence is not considering whether what intention of legislature has to be gathered when it is says there is no detailed discussion, right? You are on the strength of this judgment, you are entitled to argue that the arbitrator has to be appointed if the occasion arises to be appointed as per amended provision.
That's true. That is one aspect. That's all I'm saying. I'm not saying retrospect or prospect. The arbitrator would have to be appointed today in any event.
So then he has agreed for appointment of an arbitrator.
The next aspect is whether such an arbitrator.
Now you are arguing that the arbitrator cannot be appointed at all.
No, I am on the. That is my second contention. But I have raised 2 points.
In this case also they had filed a thing.
That is because the
termination of mandate under section. On this very judgment, You can file a objection before the arbitrator saying that your mandate has been terminated on account of amendment. This is how the case arises on which you are placing reliance.
Madhya High Court, but otherwise I'll bring the mother judgment, Lord. That would make it very clear. Mother judgment arises out of the Madhya Pradesh High Court judgment. I can, Lordship can put it tomorrow.
No, not tomorrow. This is of Mr. sufficiently old case.
That's why.
2004.
But so far as this judgment is concerned, my submission is today they can't appoint a member of their service. It has to be an outsider. That my friend has agreed. But the other aspect I'm pointing out is
That's it. That's the end of it.
that is first
That is the end of it. We will rely on this judgment and say that this appointment of an arbitral tribunal is set aside. That's why we asked you. You give an agreed name, we will appoint.
But the another aspect is about the limitation. Because if it is 11.6, I can also raise before your lordships.
In a writ petition.
Yes, the contract.
Limited
Where I am able to show the dates.
No,
Dates are clear. I am not asking any factual adjudication to be made. But it's not now as per the latest.
No, Mr. We don't know all this thing.
There are two things. But if I am
we don't know how. We would like to examine this matter in detail. Arbitrator is appointed, straightway writ petition is filed without taking recourse to the remedy provided under 15 and 16
That's true.
of the Code of the Arbitration Conciliation Act. Please tell us why we should not relegate and why we should entertain all these questions in a writ petition.
But it is like this. Not if I were to file an application under 11.6 today.
There is this thing also is a judgment of Supreme Court. This is against appointment of an arbitrator, right?
But I'll satisfy your question. No, on both grounds. On both grounds. Because I put it on the ground of limitations. If your lordships looks into the other judgment that I have passed on. Because earlier the view was, today your lordships are appointing an arbitrator. Now your lordships are exercising powers under 11.6. Not instead of asking them to make a formal application either of the parties. In a writ petition, this honorable court can exercise powers. But I am not saying no. This itself can be treated as an application under 11.6.
See, it is pending since 2004.
No, that's why let us treat it as an application of 2004.
It is in the interest of your client also.
If I treat it as a 2004 application, and if I am able to demonstrate before lordships that even in 2004 it's not, but that's what the Supreme Court said. This court will not appoint an arbitrator. The lordship may have a look at this judgment for a moment. 2021 5 SCC 705. Paragraph 12. But I just paragraph 12 is the arguments raised by the counsel. Because they were saying that explicit is barred. Paragraph 12 may I read just to give the factual background so that at page 714, it's not the conclusion. Sri P.S. Narasimha, learned advocate appearing on behalf of the appellant, submitted that the date on which the request made for the appointment of arbitrator was received by the president of Secretariat Cantonment Board on 23/1/2007. As a result of which, this is the date on which the limitation period starts under Article 137 of the Limitation Act. Insofar as the application under Section 11(6) of the Act is concerned, for this purpose, he relied upon the judgment of the High Court of Bombay and so, as well as recent judgment of this court, Geo Miller and Vidyut Nigam. He then argued that even so far as the cause of action on merits is concerned, it arose way back on 8/9/2003, when the respondent raised the claim with regard to the dispute for the first time. Once time begins to run, limitation cannot be extended by writing any number of subsequent letters. He also relied upon recent judgment of this court, Vidya Drolia versus so and so, stating that this case was under para 148 of the judgment, and that claim was expressly time barred and dead, and there was no subsisting dispute. Then there are paragraph 14, they referred to some other judgments. Then we can go to paragraph 18. paragraphs at page 720. Then paragraph 19 is the conclusion. But 17, 18, I will not trouble the Honorable Court by reading it, but it's a matter. That paragraph 19 is the conclusion. May I read 19? Lord? Applying para 19.
So when was the demand made for arbitration? Arbitrator, when was he appointed?
But the arbitration demand was made on 21/10/94. The appointment is on 24/6/2004. Roughly after about 9.5 years.
I don't know, the parties now in respect of government under 1 and 2. 112 the 30 years is a limitation.
That is for recovery of immovable properties. Government.
The parties may be not private parties, I don't know. The judgment which is the parties not in respect of private parties approval.
No, this is
137. In respect of kindly see the Limitation Act, Article 112.
Article 112.
Article 112, any suit except a suit before Supreme Court in the exercise of or original jurisdiction on behalf of the central government or state government, including the state government, that is Jammu and Kashmir, 2 years is the period of limitation.
So you are entitled to seek this thing appointment, right?
Yes.
That question we will keep open to be agitated in a proceeding. You invoke 11.6. We will keep the question of limitation open. We can argue why we decide here.
No, but I think there's a small clarification that needs to be. It's what my friend is reading is with relevant.
Oh, whatever it is, he wants to contend, Mr. This when see the scope of this writ petition is confined to examining the validity of this order appointing arbitrator. That we are setting aside.
We have raised the limitation also. I have raised the issue of limitation.
That we are not examining. If as and when we are granting him liberty to file under 11.6,
very well.
In that proceeding you can raise the issue of limitation if so advised. And our order is subject to SLP.
No.
Yes.
We don't want. I always say that.
No.
Whatever court we are arguing, we should try to get an order from there.
No. Mr. You have a stat, right?
That right would be our first fact.
Yes, fine.
And we don't want.
Mars. Please ask Mr. anything. Don't leave blanks. If you have any difficulty, ask me 10 times. I will patiently tell you. But don't leave the blanks. This case,
In cases.
where is that?
Please. Lord, insofar as these batches are concerned, Lord, I have formulated into three categories. Lord, I have prepared a comparative tables for your Lordship's convenience. Only to point out exactly where the conflict is between the state rules and the central enactment.
Which is the rule page?
Map.
Rule, what is under challenge?
I'm sorry.
Must possess properties.
Rule 4. Extremely sorry. That insofar as SGT is concerned, that the rule that is under challenge is 4.
Which all?
That insofar as SGT is concerned, my lord, they have prescribed. My lord, Lordships would find at page 41. Sir. It's kindly, my lord, a comparative table has been prepared, but to show the state rules and the NCT rules.
Hey, Mr. We had asked you to prepare a synopsis. You are not like you are without preparation. You are just ready to give a lecture to us, right?
Right. It's only, I mean, I'm only for Lordships of this comparative table. Only to point
Hey,
out.
don't interrupt when we are studying, right? Who will write the facts? You are not saying anything. We are studying. You did not challenge us. You did not even tell us which rule you have challenged. What is the requirement? What are the facts? Nothing. Wait. What to do? Madam, where are the files? There is a typed note. Typed note of 2-3 pages in the files. Give it. Files. Files. Which rule is challenged? Page 34. Different. It is not. No. This is something different. This rule to the extent of prescribing, they don't even write which rule. Which rule have you challenged? Any idea?
In secondary grade teach, insofar as secondary grade teacher is.
No, we are taking up this WP number.
4359.
First case.
Yes, ma'am.
Any idea what rule have been challenged?
Rule 4.
Which page?
I have page 40. May I request, my lord, your lordships may kindly be taken to repetition number, my lord, 1353, because this is been filed with comprehensive regulations.
This is here also you have filed regulation. That means you don't even know what rule have you challenged.
The 4,
We can thank
Rule 4, subclause 2, my lord. Page 34.
34.
Right, page.
You can also nobody prevents you from helping the court because you are here to assist. You see what type of assistance is being given to us by the petitioner. So we have to, he has not said anything. We are studying on our own because we have to write judgment. So which rule, Mr. Page? 31, 34, which rule? Secondary grade teacher, Roman 2, must possess. So 422 Roman 2, right?
Yes.
Must possess intermediate, senior, secondary as recognized 45% up to 2007 and which other rule? This is the only rule. Huh? No, rule 422 and which other rule they are challenging?
In SD.
No, first let us this thing, then we will consider. This case only, this up to this what it requires.
May I request?
NCT regulation. 1 minute, it can't be heard without hearing you, right? Can't be decided. We are trying to help ourselves, right?
Even a comparative table, my lord, for your lordship's convenience.
So, Mr. What is under challenge? This is, what does this provide? Huh? Huh? 2007. So what is challenge? That this 45% one, what is the? No, must provide intermediate 45% marks and then 45% marks they should pass in the intermediate. They are saying that we have 34%, but still we are entitled. That you cannot prescribe this 45%. So up to 2007, it's 45%. And what happens after 2007? 50%. Okay. And these petitioners want to become teachers. Less than 45%. No, they are challenging this rule. So then this rule does not apply to them. Why they are challenging it? No. This is up to 2007. If you have this thing, passed the intermediate examination, you must score 45% marks. Huh? Where is that provision? No, not under this rule, some other regulation. Arey, Mr. You also don't get it right. This you are referring to page 34. You are sailing with him, right? Don't get, this is page 28 starts Telangana State Direct Recruitment for Post of Teachers Rules 2007 and 17. And you are reading this rule 422 and telling us and saying that these are NCT regulations. Why bring in NCT when we are asking about the rules? We did not ask you about the basis. We want to understand what is the challenge. So these rules provide for 45% if you have passed intermediate up to 2007, right? So this is under challenge in these petitions saying that you don't have a power to prescribe 45%. Intermediate, even though we have less than 40%, we have 45%, we are entitled to be appointed as teacher. This is the submission. Right? See, Mr. What is the prayer in the writ petition? You are what we are not understand. Mandamus impugned, declaring impugned rule. It is totally illegal, arbitrary. It is being challenged on two grounds as we can understand. Mr. Are you sure which rule is under challenge? 422? 422, what does it provide? 45% marks, intermediate up to 2007. Right? Now this challenge is on the first ground is that it is contrary to NCT notification dated 12/11/2014, and second is violative of Article 14, 16 and 254. And see the prayer page, prayer in the petition, page 25. This can't be See how they are challenging, why I don't know, huh? No. You see, this is the petition, averment, affidavit, agreed by imposing qualifying words. Secondary grade teacher. See, these people, see, all of us have passed intermediate before 2007, right? So that means before 2007 means this applies 45%. They should have minimum 45% in intermediate. See the prayer. Allow them to appear. No. Receive application without reference to cutoff mark of 50% in intermediate. If they are before 2007, the requirement of 50% doesn't apply. No. See the prayer, page 25. Mr. Where is the other provision which provides for you jump to regulation NCT? We are still on the rules which says that after 2007 it has to be 50%. That rule is not under challenge, but we want to see 69. Huh? Not 69, mister. This is norms and standards. No, mister. Your rule only provides for that up to 2007, 45%. What happens after 2007? Supposing if a person has passed this intermediate examination after 2007. So according to you, he is ineligible, right? He cannot never appear because there is no provision. Do you understand, mister? Please read it 4 to page 34 again. Unfortunately, we have to labor so hard on this thing, prayer clause only. Must possess. No, so we are asking you that supposing if somebody obtains this thing, DLED after 2007, what happens? Where is that provision? That's what simple question is.
That's referable to clause 1.
Ah, 50% marks, correct? 45. Now, so NCT regulation, first is said, first ground is NCT notification date 12/11/2014. What is 12/11/2014? Page 83. According to petitioner, what is contrary to NCT regulation? Petitioner's case, you tell us how it is contrary to. Regulations.
Level, that page 84, level 3, man. Lordship's page.
No, this regulation is saying that first ground is two grounds, contrary to NCT regulation of this and violative of this, all general ground 14, 16 to 54. Contrary to page 84. Regulations. No, no, first is Mr. Their first ground is correct. First ground it is contrary to NCT regulation 2014. And second is violative of article 14, 16 to 54, right? So what, how they are contrary to regulation? What is petitioner's case? No. First ground is contrary to NCT regulation. So you have referred to page 83 also. What is first schedule? Minimum qualification as
that 20.
18 80. We will hear you, don't worry.
Very well.
We had told you that prepare a synopsis, didn't do anything. Just wanted to give a lecture to us. So we are helping ourselves. Fine. We will hear you, don't worry. We told you, Mr. Without hearing you, it can't be decided, right? But we are just trying to understand what is your case. So we are asking him. He will have to argue his own case. Not that we are hearing him on merits. You see, we are just trying to understand what is your case. 23rd August. Yes. No, what is the difference between this thing? Senior secondary classes 1 to 4 minimum qualification, right? Senior secondary or its equivalent with at least 50% 2-year diploma, whatever name known. No, but 1 and 2 you will appreciate. It's exactly identically worded, similar. What? Mr. These two are one and the same, or what is the difference between these two? Or 45% mark. No. So this NCT regulation, this notification permits senior secondary with either 50% or 45%. And third is at least 50% and 4 years bachelor or senior secondary 2 years diploma in special education. So no, that is on merits. We are trying to understand How is it in according to petitioner? Hey, don't argue your own case. You have a dual responsibility of explaining to us what is, so how according to petitioner this is offending. So their submission is that NCT regulation permit both. NCT regulation permit intermediate with 50.45%. Both. But how is it violation? Yes, you have also not understood how it is in contravention. Oh, this is it's something interesting, right? Counsel for respondent is not understanding the what ground petitioner has challenged, then what can you argue? All right. Page 22. Page is. Now see page 22, Mr. How you are saying that you don't understand? They have pleaded in the petition. Therefore, qualification now prescribed with only intermediate with 50%. Qualification meeting. Rahul. Rahul Reddy. You don't know. Right. We are asking for our notes. You are giving it, passing it on as if it is our notes. This is given by him. We will have a look at it while hearing. All right. This is page 22 is the challenge pleaded. Now, what is arbitrary 14, 16, 3 to 54? That's what. See, he understands that you need to use the mic.
I'm sorry.
He is unable to understand your submission, so he came. Yes.
What? Providing 50% basic 50% of the marks for intermediate, minimum qualification of 50% for intermediate, those who secure diploma after 2007, and 45% for candidates, those who secure diploma before 2007.
What is the justification? Acha, we'll come to you. Yes. So two grounds.
Yes.
One is contrary to NCT regulation.
Yes.
Second is Article 14, 16 and 254.
Yes.
So how is it contrary to?
Yes. In fact, the NCT regulations, my lord, as pointed out by your lordship, my lord, earlier in the page 84.
Page
84, my lord, referring to notification at page 80. My lord, 2010, my lord, your lordships have seen.
Yes.
Yes.
Page 80.
This, my lord, it says minimum qualifications as.
No, you are referring to what?
Page 84.
84. Yes.
My lord, it refers to a notification dated 23rd August 2010. NCT, which your lordships were taken by my lord.
Page 80.
Yes, my lord, page 80. Very good. Page 80, your lordships may kindly see the second condition, my lord. Senior secondary or its equivalent with at least 45 marks and 2-year diploma in elementary education by whatever name known in accordance with NCT. There is no reference to 2007 in it. They have altered. But your lordships may kindly, my lord, what is prescribed by NCTE does not distinguish between persons having possessed before 2007 and after 2007. Now, by adding words,
1 minute.
I'm sorry.
So they have provided an.
They have induced, my lord, a condition deleting
Which
certain
is contrary to NCT.
NCT. And these regulations are 2010 and 2014, my lord. They never put such an embargo that such of those persons who have from 2007 is never been a condition.
Yes, correct.
That is the condition. That is, my lord, therefore, my respectful submission is, my lord, insofar as the NCT
It is contrary to NCT regulations. Got it.
My lord, supplementary.
We will place it for you, Mr. Do you think that we have not understood right?
No, my lord.
Huh?
In fact,
See, the NCT regulation, your submission is NCT regulation do not make any distinction between obtaining the intermediate certificate before 2007 or after 2007.
Yes.
But
this is not, they have not put a condition for intermediate, my lord. They have put a condition for the diploma course. My lord, there's a diploma in education.
No, this is, one
What?
minute.
The condition that they have. I'm sorry.
No. We must see, I had this.
Page 34.
34.
Lord, in fact, the comparative table, my lord, I have placed for your lordships, my lord. I've just put the NCT regulations vis-a-vis the state rules. Your lordships kind consideration. The comparative table, my lord, I have. In fact, on the left-hand side.
No, I asked you to call Rahul Reddy. He is also doesn't come.
On the left-hand side, my lord, is the National Council.
Oh, we can see it at page 84 also.
Yes, my lord.
34 also. What is 34 says?
34, my lord, adds at in clause 2, that is, those who are admitted in diploma in education up to year 2007. So, only such of those persons, 45% criteria is fixed, rest all are excluded. Whereas, my lord, state has continued to allow.
No. See, Mr. Read it 422. How you are saying? Read. Must possess.
Yes, my lord. Must possess intermediate, senior secondary or its equivalent as recognized by the Board of Intermediate, Telangana, with at least 45 marks in case of SC/ST, differently abled and minimum marks in accordance with NCT norms regulations 2002. Now they add this. That is, those who are admitted into diploma in elementary education, that is DLED, up to 2007. And
So what is the twin requirement now according to our understanding? Until you provided you clarify. This for whatever you have read is two conditions.
My lord.
First is you must have intermediate exam with 45% marks.
Yes, my lord.
And must have been admitted to DLED course.
Yes,
prior to 2007. Second condition.
Yes.
Third condition is past 2-year diploma in elementary education stroke 4-year bachelor in elementary education. These are the three conditions.
Yes.
Correct?
That 2, my lord. 2-year diploma in elementary education is the same.
Three conditions. Mr. You again read.
My lord, it's intermediate with pass and 2-year diploma.
Yes.
My lord, I'm sorry, but it's only two conditions, my lord, if I may.
No, we want to understand. Yes.
Yes, my lord.
Must possess intermediate stroke senior secondary or its equivalent as recognized by Board of Intermediate Telangana with at least 45% marks. Correct? Number one.
My lord, that number 1
1 minute.
continues till the end.
1 minute. 45% mark. You forget this STSC and 40%. That forget about.
My lord.
Then, in accordance with the NCT regulation, norms regulation 2002.
That is all the first limb, my lord. And the second limb is and pass in 2-year diploma.
Correct. You are right. Two conditions.
Two conditions.
Now, what first condition is?
Pass in intermediate with 45%.
45%.
Second is diploma. Now, pass in, so far as National Council for Teacher Education is concerned, my lord, the regulations prescribe pass in 45 plus diploma. Whereas state, what they have done, my lord, they have included pass in intermediate with 45. So only such of those persons who did diploma prior to 2007. That is how they imposed the condition. That condition, my lord, made several of these persons who have prosecuted diploma from the state, my lord, ineligible.
Correct.
Therefore, yes, my lord, several of these petitioners, my lord, this, in my respectful submission, is contrary to, my lord, page 80, where the NCT has never prescribed the condition of 2007. State has prescribed. Therefore, my lord, it is bound to go, is my respectful submission. And it's irrational, my lord, because they say 2007 regulations have altered. They have themselves permitted these petitioners.
So, first is in contravention. Secondly, no rational basis of providing, linking it with 2007.
Yes.
Correct?
Yes.
Therefore, it is arbitrary and this.
Very well.
Simple, right? You said I will take 3 hours.
Right.
No. Mr. Counsel, every day is a learning experience for not only for you, for us also. See, you in retrospect think that if you have clarity of mind, how you can.
I sincerely apologize for that. I have prepared everything short from.
No question of apology, Mr. Why we are telling you is we feel sincerely earnest that you can improve. That's why we are telling that if you have clarity of mind, see how 10 minutes you have concluded.
I'm grateful.
And that day you were saying I will take 3 hours. Realize that better preparation.
I'm grateful.
We have appreciated your this thing. Yes.
But in so far as
Mr.
judgments have provided, my lord, since
which judgment?
In last occasion, my lord, your lordships were, my lord, in the earlier batch, your lordships have already dealt it, my lord, in so far as NCT is the primary authority and it is the NCT governs the field of education. That so far as rule making authority. That in fact, the compilation is short compilation.
Type notes. So what it has been taken note of right in this judgment.
Most of it, my lord, your lordships have already dealt with that.
What is the citation? Tell us why instead of dealt with and all this, we will record your submission. What? Tell us citation page paragraph number.
Yes, my lord. 2013 to SCC 617.
617.
My lord, just
paragraph number.
Yes, my lord. Paragraph 59, 60, 66, 73, 77 and 79.
What is it, this authority?
This is a case, my lord, where National Council for Teacher Education governs, my lord, with respect to teacher admission courses as well as recruitment, my lord. National Council for Teacher Education has laid down guidelines so far as admission process and recruitment. State has framed, contrary to the National Council for Teacher Education, the Honorable Supreme Court said that once the rule is governed, Para 60, my lord, page 32, your lordships may kindly be taken to in the compilation.
Page
32, my lord, Para 60. 59 also is there, my lord, but I'll read the operation. Page 60.
We are dealt with this, no?
No, my lord. Earlier round, this was not dealt. The NCT Act has been enacted by Parliament with reference to Schedule 7, Entry 1, List 1, Entry 66 of the Constitution. There is no such specific power vested in the state legislature under Schedule 7, List 2. Schedule 7, List 3, Entry 25 is the other entry that provides the field for legislation both to the state and center in relation to the education, including both technical education, medical education, universities, vocational training, so and so. The field is primarily covered by the union list, and thus the state can exercise any legislative power under the List 3, Entry 25, but such law cannot be repugnant to the central law. Wherever the state law is irreconcilable with the central law, the state law must give way in favor of the central law to the extent of repugnancy. This will show the supremacy of the central law in relation to the professional education, so and so. Well, then your lordships may kindly be taken to, my lord, para 71, 71, my lord, I'm sorry. That the examining body, so far as the NCT is concerned, my lord, is the examining body, my lord. It can impose certain conditions, my lord, by the NCT are complied. My lord, it also is the body which has to take care of the rules are, the state rules are in consonance with the NCT. My lord, in so far as this act is concerned, my lord, once the NCT has framed the National Teacher Council regulations, the field is governed by the central enactment. The state has no power. In fact, this, my lord, was also considered by your lordships in the earlier round, my lord, when the learned senior argued. My lord, once the field is governed and covered by the NCT, my lord, the state may not have a requirement to frame rules also, because the state center is already governing the field. My lord, now NCT regulations, my lord, already which have been filed before your lordships in 2014. This also, my lord, your lordships were pleased to, my lord, address in the earlier order. My lord, I'll just read, my lord.
So, which is the other judgment?
My lord, other judgment, my lord, your lordships may kindly be taken to. That state of UP versus Anand Kumar Yadav.
Why have you made it so small, right? Unreadable. Or it should be, the code should be, strain should be caused to the eyes of the code so that difficulty in reading.
Extremely sorry.
You could have,
yes,
what is this? Whole page you have left blank and small. Yes.
Apologize.
Which page?
Let page 54.
Anand Kumar Yadav.
Page 54.
Yes. Which para?
Page 54, the judgment starts at page 54. Minimum qualifications at page 62, my lord.
No, which para?
Para 8, my lord.
Para 8. Yes.
Even though by notification dated 23rd August 2010, minimum statutory qualifications was laid down by NCT, the issue of relaxation under section 23(2) of the Right to Education Act was taken up by the Union Government for relaxation for limited interim statutory period, and if state did not have adequate institutions for teacher training and did not have adequate number of candidates for the period. The state government, in response to the letter of the central government, responded by stating that it had adopted Shiksha Mitras on contractual basis who were required to be given teacher training.
Hey,
para 10.1, the impugned notifications, my lord, your lordships would say at 11.3.
What is the proposition, Mr. Reading all this?
My lord,
you are diluting the effect of submission so meticulously made by reading irrelevant thing.
My lord, in this, my lord,
there is no notification amending UT.
I'll sum up the case.
Proposition,
yes,
Mr.
In this case,
you must cite the case law and say this is an authority for that proposition. Then you can tell us this was the factual background. This is what Supreme Court has said.
In this case, my lord, the Honorable Supreme Court held that NCT regulations have to be scrupulously followed and cannot be relaxed or tinkered in any manner. Because, my lord, in the state there, my lord, what they have done is they have given
para 8.
Yes, my lord.
That's it.
Lord, para 21.4, my lord. 21.4 deals exactly the question, my lord, whether statutory qualifications in the central statute on concurrent
21.4,
my lord. 76.
So you should have gone straight with there. No reading 10.1, nothing. This is what is diluting the effect of such submissions made. All reading irrelevant things. Yes.
21.4, page 76, whether statutory qualifications in a central statute on concurrent list subject could be relaxed by the state government administrative action.
That can't be done. Answer is obvious. Nobody can do it. Which
Here-
answer is where? Which paragraph?
Para 27. Right, it has dealt with
Page,
the-
page.
Page 83.
Huh?
83, ma'am. It has dealt with the facts and law both, my lord. Page 27. But then, my lord,
They examine, then read what is para 27.
yes, my lord. But we may now further examine the question whether Shiksha Mitras have under the law right to be appointed or observed as teachers dehouse the prescribed qualifications in this regard.
This is not the case that you have a right to be prescribed.
That
is not the case or your case.
My lord, the Honorable Supreme Court went on to say, my lord, that later in the same paragraph, later, my lord, it's a very.
There are 28. The conclusion is that
Para 28, my lord, your lordships may page 90. We are in agreement with the above findings in view of the clear mandate of law.
Mr. You please understand the question which Supreme Court has answered is that no person can be appointed divorce the qualification prescribed under the
NCT.
rules. You say that I am not having any qualification, still I should be appointed divorce the rule. Not your case.
No, ma'am.
Then how does it apply? That's why we told you that excellent submission made on propositions. You are diluting the effect by relying on irrelevant case law.
Insofar as the Act, Lord, NCT Act has already.
Which is now you have cited 1 and 3. What about 2 and 4 of your compilation?
They also, my lord, deal with the same aspect, my lord, that NCT is primacy is NCT. That's all. So already your lordships have already held earlier.
You tell us which paragraph. We will otherwise we will not refer, Mr. We will not refer. We will only refer to 2 judgments. And second judgment is irrelevant, whatever you have read, because it is not your case that you have a right to seek appointment, divorce the qualification prescribed. You don't want any relaxation.
No, my lord.
So this is a case, the state of UP is a case dealing with that.
Yes.
Whether Shiksha Mitras or whatever have the right to be appointed, divorce the qualification prescribed. That is the case. Supreme Court has said nobody can be appointed in face of statutory qualifications prescribed by the rules. Not your case. What about 2 and 3? You are not relying.
My lord, 2 and 3, Devesh Sharma case, my lord, was a very recent judgment, my lord, where the Honorable Supreme Court has dealt.
Devesh Sharma, you just relied para 8. No, Anand Kumar Yadav.
Anand Kumar.
Yeah. Devesh Sharma is what paragraph?
My lord, several paragraphs, my lord.
Don't see, Mr. One judgment of Honorable Supreme Court is sufficient under Article 141. See, you did not give 15 judgment that NCT is.
I leave it there. I will not refer to those.
You have only relied on 2 judgments.
Yes, I leave
Vaishno Devi and State of UP.
Yes,
right. Yes, Mr. Now you have understood the challenge.
Yes.
What is the challenge? Tell us.
Why?
No. What have you understood? Tell us. Then only you can argue. First instance, you did not understand his challenge.
The challenge is that we are not prescribing 2 different qualification cut-off marks.
No. NCT regulation do not provide for any distinction.
45% and 50%.
After 2007, before.
Prior to 2007, after 2007. Therefore, it's arbitrary and in violation of Article 2.
No, therefore it is contrary to NCT regulations.
And also
Where have you got it? How have you got it, Mr.
Now this page for, again I may request your worship to go to page 80, my lord, material papers. These are qualifications A, my lords.
No, see, Mr. What he's saying is did you get it now?
Yes.
45% of the marks in intermediate examination in those who are admitted to DLED. What is DLED course?
Diploma in Elementary Education.
Elementary education course up to the year 2007.
2007.
Where have you got this? I mean, NCT regulation.
NCT regulation.
1 minute. You have taken us. Please understand. Don't be in a hurry. Please understand the point. What submission made is page 80 you have taken us and 83 you have 2010 notification. The contention is that the NCT regulation do not make any such distinction that candidate who has passed, who was admitted in DLED course to 2007 and who possesses 45% marks in intermediate examination alone is entitled. The NCT doesn't say. It says 45, 50%, 45%, then another qualification or four qualification. Where from have you got it within bracket 2007?
No, this qualification without 45% is in accordance with NCT recognition norms and procedure regulation.
No, he is not questioning 45%, Mr.
No.
He is only saying where from the in 45%.
The 45%.
And the candidate must have taken admission to diploma in elementary education up to 2007.
Up to 2007.
Where from up to 2007? Where from have you got it? This is up to 2007 is the challenge.
Yes, ma'am.
That it is arbitrary. It is in violation of NCT regulation.
No,
Number one.
May I say it, up to in 2002 regulations for admission, there are two regulations. One is for procedural for recognition and admission, and another is providing qualifications. Qualifications for appointment.
Which regulation?
This is referred to in this rule itself, page 80. 45% is in accordance with NCT recognition norms and procedure regulations 2002. 45% should be only with reference to the candidates.
Which page?
Page 80, my lord.
80.
80, my lord. 80, this or second qualification of 45% is qualified with in accordance with NCT recognition norms and procedure regulations 2002. This NCT recognition norms and procedure regulations 2002 is at page 53, man.
Following minimum qualification in teacher in class 1 to 8. Yes.
This is in accordance with NCT recognition norms regulations 2002. Now you may I request your lordship to consider this regulation 2002. That's at page 53. Then eligibility for admission is at page 69. Man. At 70 minute, this is 3.2.
This is what?
69 is appendix 2.
NCT form of application for recognition. Time limit of submission of application, determination norms, standard for recognition of teacher education programs, and permission to start new colleges.
Now this eligibility minute, page 64.
No, Mr. We don't know what. You first read also that preamble and then this thing regulation 2.
In the initial.
All right, let's see. Which regulation?
Under this, under regulations, appendix 5 at page 64. This is eligibility for admission to elementary education.
No. Fine, 45%.
45% with senior secondary examination is equivalent or eligible for admission. These regulations are modified in 2007, providing 50% is minimum for in intermediate to get admission into diploma in elementary education.
Where is?
That's at page, it starts at page 69, mothers.
Norms and standards. Appendix 2.
Yes, ma'am.
This is not a statutory rule, something.
So this is at page
69.
69, page 70, mothers. Eligibility. Now this eligibility is changed to, earlier it was 45%. For candidates with at least 50% marks in the senior secondary examination or +2 or its equivalent are eligible for admission. So since
Mr. 1 minute. Appendix 2 is what document?
I'm sorry, my lord. In fact, these papers are filed by the petitioner. The original regulations are not filed.
No, what is like, you must tell if you are relying on this document.
Yes.
You must tell us what is appendix 2.
This appendix 2 is 2007 admission regulations. This appendix 2 is attached to 2007 admission regulations, my lord. In fact, I explained in my counter. Proceed may take my counter affidavit.
No. See what is, we will take to your counter also. Come to page 54.
Yes, ma'am.
These are, what is it called? Read the long preamble. These regulations do not provide for this thing.
These regulations provide recognition of courses and admission to the courses. Norms and standards for various teacher education programs. So the standard provided for admission into a teacher education program, that is diploma into elementary education, is 45% intermediate prior to 2007 and 50% after 2007.
And come to page 83 then.
Yes. Yes, ma'am.
Determination of minimum qualification for person to be recruited as education teacher and physical education pre-primary, upper primary, so and so regulations 2014. This is under clause DD of subsection 32 read with section 12A of National Council for Teacher Education Act.
Yes, ma'am.
And this is something else, right? These
are issued under regulation subsection 2 of section 32, madam. The earlier regulations.
32. Let's see NCTE Act. Section 32. This will apply. Directly dealing with qualification. This is for admission. Yes. Application of admission, form of application for recognition.
32 is power to make regulations.
Power to make regulation for what?
There are different provisions of it. Council may by notification the official make regulations not inconsistent with the provisions of this act. And rules may
1 minute. Teacher Education Act, right?
Yes.
Section 32.
32.
Yes.
Council 32(1), my lord. Council may by notification.
Power to make regulation.
The council may by notification the official gazette make regulations not inconsistent with the provisions of this act and the rules made thereunder, generally to carry out the provisions of this act. In particular and without prejudice to the generality of the foregoing power, such regulations may provide for all or any of the following matters, namely time and place of meetings. D, your lordship may kindly consider. Clause D. Norms and guidelines and standards in respect of minimum qualification for a person to be employed as a teacher under clause D of section 12. The specified category of courses or training in teacher education under clause E of section 12. Starting of new courses or training in recognized institutions under clause F of section 12. Standards in respect of examinations leading to teacher education, qualification report in clause G of section 12. The tuition fees and other fees chargeable by institutions under clause H of 12. The scheme of various levels of teachers' education and identification of institution for offering. TD, the qualifications of teachers under section 12.
This is Mr. D3, starting of new courses, right?
Yes, my lord. Training in recognized institutions, clause F of section 12.
So this is, in fact, this can be traced under section 32.
2D.
2D Roman 3.
Roman 3.
Right?
Yes, ma'am.
And there is another specific power under clauses DD.
Yes,
got it? Huh?
Yes, ma'am.
And if you see the previous notification, regulation.
Yes.
Right? It is under section 12A and clauses DD of section 32.
Yes, ma'am.
So it is specific,
No, one is under section 12A.
one is under 12A read with clauses DD of subsection 2 of section 32.
Yes, ma'am.
So it is a special provision. Special provision will prevail over the general provision which is in relation to new course or training. Incidentally, it provides with reference to that you cannot give effect to this 2007, pre-7 and post-7, nothing. This whole thing is misconceived.
No, no, my submission is not both conditions are to be
No.
money.
What you are saying is this thing we have understood. That the qualification has been prescribed in accordance with 2002 regulations.
2002 regulations.
2002 regulations were amended in 2007. Therefore, you have said 2007 up to this
45. Thereafter 50. That's what we said. Because a person cannot get a diploma.
Mr. Please understand, Mr. This again, even if we accept this submission, that is why please think about it. It's not like we don't speak because lawyers feel that we are their enemies and trying to understand. Like it's a debate, intellectual debate. Because they feel like immediately they will start. No, 1 minute. We are trying to, it's a debate, right? The debate is, you understand his challenge. He is not saying 45% you don't have power to prescribe. 45% is fine. What he is saying is, again come to page 34.
Yes.
34 is in two parts, right?
Yes.
Clause 422. Mr. Got it?
Yes.
It is in two parts. First part is, candidate must possess 45% marks in intermediate.
Yes.
And should have taken admission to DLED course up to the year 2007.
Yes, ma'am.
One condition.
Yes.
And 2-year diploma in elementary education or 4-year bachelor in elementary education, second qualification. He is challenging the first requirement that DLED up to 2007 only.
Yes, yes. Limiting it to up to 2007 is challenging. I understand.
He is saying that the regulation does not make any such a distinction like up to 2007 and then 50%. And your submission is that we have done so because your submission is that this regulation.
It's page 53 regulations.
That which clause of the, let us note down otherwise. Page 53, right?
Yes.
54.
54, it starts at 54.
In consonance with NCT regulation.
Yes.
Page 54.
Yes, madam.
Right?
Yes.
Which clause? Regulation. Which regulation? You are referring to some regulation, right?
This is annexure mirror. We have referred to
Page 64.
Page
64.
64, madam.
Page 64. So what happened then when it was amended?
It was amended in 2007, madam. That is.
Where is 2007 amendment?
That is not here, my lord. There are in other bundles, my lord, because so many case files are there. In fact, petitioner has not filed that, my lord. It's there in other files.
You have to fight.
Yes, my lord, I
What is 2007 provided?
this 2007 annexure is filed, my lord. Here it is the minimum qualifying marks in intermediate is 50% for to get admission into diploma in elementary education. That's at page 70, my lord. Though the regulations are not filed, the annexure is filed. Appendix is filed, page 69.
You give us a copy just now.
Yes, my lord. I'll give the copy, my lord, immediately.
Now only, within 15 minutes.
Very well, my lord. Just immediately. This appendix is filed, my lord. This is 2007, appendix to 2007 regulations. This is page 70, my lords. Eligibility. Candidates with at least 50% marks in senior secondary examination of +2 equivalents are eligible for admission. Therefore, according to this method, a candidate who is having less than 50% cannot get admission after 2007 into the diploma course. Only in that context, we said that prior to 2007, 45% with intermediate is eligible, and after 2007, 50% with intermediate is eligible.
Arey, Mister, but if that is so, then come to clause 1.
Contradicting. Clause 1 is
Clause 1 of page 34.
Yes, 50%.
Read it.
Yes.
You don't say that in candidate after admitted to DLAD course after 2007.
We don't say that.
So it doesn't make sense, right? If you read both clauses, they do not make any sense.
Of course, providing this 40 same regulation without one or with 50% or 45% appears to be.
No. 45%, 50%, and it doesn't say that is those who are admitted to DLAD course after 2007.
Yes,
that is missing.
That is missing there. But that is, we have limited.
It is not. Don't you think it is incongruous? It doesn't make sense.
No. This is 50% to persons who are prior to 2007 or after 2007 are eligible. Those who are having minimum 50%. But
you have asked Mr. What after 2007?
Yes, madam. The first, from what arguments are being advanced? I have passed after 2007.
We are asking you something. Answer that. We
Yes,
will hear you.
Yes.
You have passed after 2007. How many marks? Less than 50%.
Intermediate less than 50, my lord, but diploma is completed under the state government's institution only, my lord. We have all taken admission into this.
No. So supposing if those who are admitted to DLAD up to 2007 is struck down,
my lord,
you become eligible under 422.
Yes.
Correct?
Yes. Because we have prosecuted diploma from the state. We have not done from private. State has given notification even after
the validity of the provision does not depend.
We will become eligible. We will become eligible.
So, Mister, do you see what basis you are making a distinction? That basis is not discernible. Got it?
I got it, my lord. So far as this
give the regulation.
Appointment regulations are, it doesn't make any distinction. But the admission regulations make a distinction.
The regulations, Mr. Please appreciate. Prima facie, we are inclined to think that those regulations do not apply because there is a specific provision with regard to teacher this thing, and it doesn't make sense.
No, I understand, but
that we don't say that after 2007 50%, before 2007 45%. That your rule doesn't say so.
Yes, my lord. In the first part of say it doesn't say 50% after 2007. That is true, my lord. The first part of the rule say
it doesn't make what it doesn't rule does not clarify your stand what you are taking in the petition that since the regulation provide we are doing like that.
That is true, my lord. I understand, but I only try to justify this, my lord. But
we don't know where from have you got this 2007.
Anyway, I'll pass on the regulations, my lord.
That's it. Anything else?
That's it.
You want to argue? No. Anything else,
But
Mr.?
so far as this batch is concerned, my lord, nothing. My lord. There's about 8 cases of this matter, my lord.
Arey, Mr. Then why have you got it like this thing tagged together if each case is different?
My lord, they're all, my lord, they were all tagged together at the first instance in 2017, my lord, all being the challenge to the rules. And only in all
Which
these
cases are covered by this?
My lord, I have taken down, my lord. Serial number 29, 37.
1 minute. Hmm.
29, 37, 41, 44, 45, 50, 52.
1 minute.
I'm sorry, ma'am.
50.
52, 57, and 58.
I got 32.
32 is also same.
Yes, same. 34 is also same. 34 is also same, right? It is filed by another council.
Another council.
Same.
Same.
29, 32, 34, 37, 41, 44, 45.
38 is also there. 38 is also
same.
Similar nature.
No, similar means same rule.
Same.
422.
Same.
Don't say similar nature.
Same rule.
And then 50, 52, 57, 58. What are the other cases, Mr.?
My lord, serial number 31, 35, 48, 53, and 55.
What are the other cases?
Pertain to physical education teachers, school assistant teachers, and language pandit teachers. In all these, my lord, same. There is a variation from the NCT regulations and the state regulations. That's the only ground.
No. So supposing if we decide this point, will it not govern the disposal?
My lord, the rule positions are different, my lord, in each of these. Except the rule position, rest all would be the same, my lord, as your lordships already.
So why are you keeping it pending, Mister? And saying different? Which rule is under challenge in that bunch?
Insofar as school assistant is concerned.
No. See, Mister, supposing if we assign detailed reasons in your case, this bunch, and say that for the reasons assigned by us in the bunch, challenge to rule whatever different rule fails or is rule is struck down will suffice. So you tell which cases this thing?
My lord, serial number 31, 35.
1 minute.
Yes, this is with respect to physical education.
31,
35, 48, 53, 55.
These people are physical education.
Physical education teachers, my lord. In this rule 4, subclause 4 is under challenge. My lord, they have no, my lord, they have taken away 2 qualifications prescribed by the NCT. They have deleted completely. My lord, sports.
Then we will hear you.
Yes. Other matter also is like that. They deleted one of the 2 qualifications and 1 qualifications in 2 matters. In both these other matters, my lord, they deleted the qualification.
Which rule? Tell us.
Insofar as physical education teacher is concerned, rule 4, sub rule 4.
Page 34.
Yes, my lord.
Rule 4. No, not 34, 35.
4359.
Is there at minute? Physical education is at 34 M max.
M.
My lord, physical education teachers is at page 36, bottom.
Page 36.
In this, my lord, there is 2 clauses from the National Council of Teacher Education. One belongs to sports category, which is deleted.
It is a different provision.
Yes.
We will deal with this bunch.
May I request? Tomorrow I got some, I'm out of station, Virat.
Nothing to out of way. We will, you supply, we will dictate the order now in the chambers.
No, with reference to.
No, you want to continue, we can dictate here also, but no point, right?
No, so far as other cases are concerned.
Other cases tomorrow.
Tomorrow I am out. That's my request is, it may taken up on Monday or in. Tomorrow I got some, I'm out of station due to personal reasons.
Saturday.
No,
Saturday is a working Saturday, 23rd.
tomorrow and day after, my lord, I am.
Oh, not there.
I'm not.
Tomorrow and day after is Friday.
Tomorrow is Friday. Sir.
Tomorrow is, okay, yes, yes. Monday, Monday we can have 25th.
Very good.
So, madam, item number, you tell us which item number.
Yes, 31, 35.
No, item number 30 also, right?
30 is also there. That's also physical.
Item 30, 31,
35,
33, 35, 1 minute, 33, 35, 36, 39, 40, 42, 43,
Further submission.
irrational criteria violative of Article 14, we are inclined to think so. This thing don't, judgment will be dictated today. Tomorrow you will be able to know the result. It's being dictated. We don't want to sit here and dictate. No point. You find out tomorrow what has happened. We are dictating the order. These petitions are
Yes,
disposed.
my only further submission is not already several appointments are already made. My lord, my lordship may not disturb those appointments. Pursuant to the notification and selection process, my lord, already appointments are made.
That what happens to petitioners?
Petitioners who are qualified in so far as Hindi teachers are concerned, my lord's direction is to, if they are eligible, let them consider vacancies are exist. Vacancies exist.
All right.
Oblige.